state capture, corruption and fraud in, amongst other things, state-owned entities. And there are more than one state-owned entity that falls under the umbrella of aviation. There's SAA itself, there's SA Express, there's AXA, and there are also certain subsidiary divisions of SAA which have fallen within the mandate of the investigation. For this evidence session and those 4 focus areas, we will be concentrating on aspects of the investigation in SAA and in SA Express. We will not be dealing with AXA and other related divisions. That will come in due course. In respect of those 4 areas, Chair, just to outline them at the outset. The first area relates to a 15 billion rand capital raising that SAA embarked upon in 2015 and 2016. The second area involves a transaction between the Northwest Department of Transport and South African Express Airways. The third area of investigation relates to jet fuel procurement that was engaged in by both SA Express and SAA with a particular company called EML Energy. That investigation will take us to some extent beyond the aviation sector, because there was also a funding component of that area of investigation that involved the IDC, and so there will be some evidence in relation to that. And Chair, the fourth area will be a topic of governance generally. In that fourth topic, we return to SAA and we look at aspects of the manner in which governance was misapplied and procurement was intervened with over periods of the various memberships of the board of SAA, and we track that over a period. So, Chair, if I may just delve into each of those, which I've highlighted in summary.
Maybe I just want to note those, just repeat them,
Indeed.
just the focus areas.
So the first is the 15 billion rand debt consolidation of SAA.
Yes.
The second is the Northwest Department of Transport's agreement with SA Express. That related to the Pilanesberg and the Mafeking airports.
Mm-hmm. Yes.
The third area relates to jet fuel procurement by SAA and SA Express with EML Energy. And as I highlighted, there's a related link there to the IDC and funding.
Yes.
And then the final topic, Chair, is governance.
Yes. Thank you.
So just to give a little bit of background into each of them and what the evidence that will be presented to you will cover over the next matter of weeks. Chair, the 15 billion debt consolidation that SAA embarked upon in 2015 and then continued with in 2016 has been the subject matter of much media attention previously, as well as at least 2 reports, which I will come to in due course. The investigation has uncovered that there were various stages of this debt consolidation exercise. And you will see through our witness today that it spans a good period of a year, and there is some complexity in the nature of the various transactions at points. But the upshot of the evidence is that but for the actions of the witness you will hear from today, who was a whistleblower, South African Airways would have either paid 325 million for funding in circumstances that it could have got that funding for in the region of 85 million, or 50 million rands would have been paid to an entity for no value whatsoever. So but for the actions of Ms. Cynthia Stimpel, who will be our first witness today, those funds would have left SAA and arrived in the hands of parties who will in due course come and give evidence and account for their position. Chair, this aspect of the investigation will also take us to the Free State, because there's an element of this funding arrangement that involved the Free State Development Corporation, who presented itself as a potential funder to SAA in circumstances where that was clearly beyond its mandate, legislatively prescribed. It also takes us to the Free State because there's a particular entity called GRISAG AG, who is the consistent funder over this period from 2015 to 2016, albeit that it keeps returning through the guise of different entities who are the interface between SAA and the sourcer of funds. And there will be evidence indeed also from the director of GRISAG in due course about its involvement in this debt consolidation. Chair, that is a broad overview of that first area of evidence. We will cover it today, tomorrow, and for at least the duration of Tuesday, because Monday is a public holiday, as the schedule currently stands. Chair, the second area involves the Northwest and its Department of Transport and an arrangement it entered into with South African Express Airways in order for South African Express Airways to fly routes to Pilanesberg and Mafeking airports. This too has been an aspect that has received public attention, most notably in an article in the Financial Mail in May of 2018, last year, by Karen Morn. It's an article that really formed the basis for much of the Commission's investigation in this area. There has also been litigation in relation to this aspect, but the upshot of the evidence that you will hear in the course of next week is that the agreement that was concluded between the Northwest Government and South African Express Airways was envisaged to move 400 million rand out of the Northwest Government into SA Express and a third party that SA Express nominated to do certain ground handling services at those two airports. What the investigation has shown and what the evidence will cover is that a total of 97 million of that total amount of the order of 400 million was paid out of the Northwest Government and then siphoned off through a detailed scheme of money laundering. Where precisely the cash ended up in that scheme is not entirely clear, but the evidence will indicate at least 3 possible destinations for the monies. The evidence will include a tape-recorded conversation between the previous South African Express commercial manager and one of the witnesses who will be testifying before you, in which he says that he used the cash to pay off 2 ministers, a premier, an MEC, an HOD, and a CFO in the Northwest. The second possible destination will come from testimony from the then security manager of South African Express, who will also be a witness in these proceedings, who was offered a 3 million rand bribe to drop his investigation into the matter, and who was told that the money was being used to fund the ANC's political campaigning. And the third possible destination will arise from testimony from persons whose companies were used to, quote, clean the money. And they will give us insight as to where that money ultimately ended up. Chair, this aspect of the investigation has highlighted one concerning feature, and that has been the slow pace at which criminal prosecutions have progressed in relation to these events, because, Chair, the evidence will show that as early as 2016, charges were laid in relation to this conduct. And there has been an investigation. Last week, in fact, the Commission engaged with the national head of the Directorate of Priority Crime Investigation, Lieutenant General Labia, and he has provided a report to the Commission which details what has happened in this investigation. Of concern, and we will raise this with you in due course in the evidence, Chair, is what appears from that report to be the case is that it has taken approximately 2 years to get bank statements from one bank in relation to one entity. And during that period, there has been very little progress in these cases. We raised that as an aspect of concern, and we thought it appropriate to get an update from the Directorate as to where the case is. Chair, the third aspect, which is the jet fuel arrangements between SA Express, SAA, and EML Energy, will involve evidence that relates to a contract that EML Energy procured first with South African Express Airways. Now, that contract appointed EML, who was a company stationed at the Denel precinct next to OR Tambo Airport, to supply 18 times more fuel at Pilanesberg Airport than the airport could use. It was also a contract to supply OR Tambo Airport with 25 million litres of jet fuel when EML Energy had in fact not been formally appointed to provide those litres at all. Its only formal appointment related to fueling and defueling 2 aircraft in hangars at OR Tambo Airport. So the upshot of that evidence will be that EML Energy obtained a grossly inflated contract for jet fuel from South African Express, which it then presented to the IDC as a basis to secure funding from IDC. IDC granted a total of 12.5 million rands worth of funding. Chair, in the context of the numbers that are generally flown around this commission, 12.5 million is paltry. But our approach in the investigation has been to uncover any monies that have been corruptly or fraudulently taken from the public purse. And in pursuit of that aspect of this part of the investigation, evidence will be presented that indicates that the IDC official who first brought this funding application to the IDC ended up as a beneficiary of the IDC money. The second aspect that will be traversed with the IDC through its evidence is that on the basis of the documents presented to the Commission relating to that funding decision, it ought never to have been approved. And it ought never to have been approved for a number of reasons. The first is that EML Energy did not originally qualify for the preferential pricing it obtained. Secondly, the finance team which assessed the application and determined whether EML would be able to service the loan that it was to receive from the IDC, erroneously added a 6 million rand to the cash position of EML that simply did not exist. And furthermore, the IDC's entire due diligence of the arrangement for funding was premised on a contract that EML was supposed to be awarded by SAA, which it ended up not being awarded. But then when it presented this alternative inflated South African Express contract to the IDC, no further due diligence was done at that point. The IDC's Chief Risk Manager will give evidence, and those points will be put to him in the course of his evidence for comment. Chair, the final aspect is governance. And the evidence that you will hear in relation to this topic will deal firstly with the extent of interference, both from shareholder level, sitting in the Ministry of Public Enterprises, as well as at board level in the management functions within SAA. Chair, you've already heard some evidence on that from Ms. Carolus. She gave evidence towards the end of last year. You will recall that much of her evidence related to meetings that were taking place with Minister Gigaba, his advisors, which she in fact did not attend. Those were attended by the then CEO of SAA, and we will have evidence from her directly about those events and others. Chair, you will also hear evidence in relation to the culture of intimidation and threats that pervaded South African Airways for some period of time under Ms. Mieni's leadership. You will hear evidence how members of the board instructed management to conclude certain contracts without processes having been followed. And you will also hear evidence of board members cancelling contracts after due procurement processes had been complied with, only then to put South African Airways in a position as a defendant in legal proceedings when the originally successful tenderer sues because of the unlawful revocation of its award. Chair, you will also hear evidence from the former head of procurement at SAA, who was threatened with violence if he did not comply with the demands made of him, and who was suspended the day after he met Mr. Des van Rooyen on the 2nd of December 2015. Chair, at that meeting on the 2nd of December 2015, Mr. van Rooyen, on the account of this witness, demanded that 2 contracts be awarded to companies with whom he had connections, and displayed a level of knowledge of the internal decision-making of SAA at the time, which was not public knowledge. The day after that interaction, the former head of procurement was summarily suspended, and he left the country, most notably because he was concerned for his safety. Chair, the evidence will also focus on the human toll of some of these acts and conduct. The procurement manager whom I've referred to, who fled to Zimbabwe, has not found employment since then, and that was in 2015. Each of the managers who stood up to the attempts to interfere with processes were generally suspended at a point and engaged in lengthy periods to fight those suspensions, but by and large gave up at a point because it became simply too long and too arduous, the consequence of which was that they often lost out on benefits to which they would otherwise have been entitled if they'd had it in them to continue fighting. Chair, that provides a brief overview of the course of the evidence. The witnesses will follow in that order. We'll deal first with the 15 billion, then the Northwest engagement, the jet fuel deal, and we would conclude with your leave on the governance aspects. Chair, it's then important for me just to highlight what will not be presented in this evidence session. I've indicated previously there's this session of about 2.5 weeks, and then the intention is to have a second session at some later point in the course of the year. As I've indicated already, there are particular other companies and divisions which will not yet be covered in this evidence, but there are also important follow-ons, particularly from the theme you will hear in the last session on governance, that need to be rounded up and will be concluded in the presentation in the second session. Chair, in terms of forensic reports, the evidence before this commission previously has included often either evidence from those who prepared the forensic reports or a submission of the reports to you, Chair. The approach that has been taken in the aviation workstream was to use those reports where they exist to form a basis for the investigation. And through the course of the investigation and the witnesses from whom you will hear, those aspects that have been highlighted have been probed, verified, interrogated. So you will not be hearing evidence from the investigator. You will instead, Chair, be hearing evidence either from those who participated in this conduct or those who stood up to it at portions of their engagements at SAA and SA Express. Chair, in terms of the reports, just for your records, in relation to the first theme, there were 2 reports. I say reports, I must say that broadly because there's a forensic investigation report dated 24 October 2017. That is an MJS report. As I said, it has been the basis for investigation, and you will hear firsthand evidence from those who were involved in the 15 billion capital raising enterprise. The second report, I'm using that broadly, is actually a set of disciplinary findings by Advocate Nazir Kasim, SC, who sat as the chairperson in the disciplinary inquiries that were brought against the former CEO and CFO of SAA. Those findings have been included, in fact, in the evidence pack you will be working with today, Chair. In relation to Northwest ground handling, there is a preliminary report of the security manager at South African Express Airways, which also formed a basis for our investigations. He himself will be giving evidence, so that report will be an annexure to his statement. And then there was a report done by Matlala von Metzinger attorneys for South African Express. That was finalized on the 10th of May 2018. But again, you'll hear evidence from the very people involved in those engagements. And then finally, on the EML jet fuel deal, there was a report done for South African Express on the 4th of December 2018 by the attorney firm Hogan Lovells. And that again was the basis for investigation. Interestingly, that report itself referenced the IDC leg of the funding arrangement, but could not go further. We've endeavored in the investigation to do just that and understand precisely how that funding was secured from the IDC. Chair, then just in relation to process aspects. Chair, in advance of this hearing today, numerous Rule 33 notices have been sent to implicated persons. The tally as I have it at the moment is that there are a total of 69 notices that have been prepared. 61 of those have been processed. 8 of them are, as we speak, still in the process of being issued because we still have 2 weeks in the course of the investigation evidence. Chair, the successful delivery of those Rule 33 notices has in general been good. There have been occasions where issues with annexures not arriving at implicated persons have been raised. There have been steps taken to remedy that. And should it become pertinent at any point, I will delve into those details for your benefit, Chair. Arising from those Rule 33 notices, we have only at this point received 2 applications for cross-examination. Chair, those have come from the former CEO and CFO of SAA, and they relate to the evidence of the witness today, Ms. Cynthia Stimpel. Chair, with your leave, it is our proposal that in the course of Ms. Stimpel's evidence, she will be asked about the contrary versions that have been put up by those 2 applicants for cross-examination, so that her answer to them can be provided. Thereafter, one of the 2 applicants for cross-examination is herself giving evidence, the former CFO. So we will endeavor, with your leave, to probe with her those aspects that emerge from Ms. Stimpel's evidence. And it is our suggestion at the conclusion of that process that, Chair, you then consider the applications. Our sense is that it may be that some of the points of contention are resolved through putting those questions in the course of evidence, because we now have the benefit of the implicated person's version, given that they've produced a statement in both cases to the Commission. And it may even be appropriate at that point to inquire from them whether they persist with the applications, and then those can be dealt with in due course. That is our proposal in relation to that aspect. Chair, finally on process matters, all of the witnesses, 15 of the witnesses, there are 16 in total. The 16th witness has not been summoned because he is resident in Zimbabwe, but arrangements have been made for him to come to South Africa for his evidence. The remaining 15 witnesses have all been issued with summonses. In terms of the effective service of those summonses, I can report that we have received confirmation of effective service in 11 of the 15 cases, and in the 4 that remain outstanding, efforts are being made as we speak to secure successful service in relation to those summonses. Chair, just a moment on the witnesses and the summons process and the type of evidence that will be received in the next 2 weeks. Chair, the witnesses come with different levels of eagerness to this commission. There are those witnesses who come voluntarily. There are other witnesses who come with caution. There are witnesses who also come with some level of fear, and that has been relayed to the Commission, and the security procedures have been engaged for that purpose, for assessment and wherever necessary, necessary protection. They also, however, Chair, come reluctantly in some respects to the Commission. And it is in that context that we thought it appropriate at the outset simply to highlight the provisions of Regulation 8 of the Commission's regulations, Chair. You'll recall, though, that is the provision of the regulations that speaks to the requirement of witnesses to answer the questions that are put to them. The only caveat to that is where the answer will divulge or fall within the ambit of legal professional privilege. But even self-incriminating answers in the context of this commission must be given, because there is a use immunity provided in Regulation 8.2. Regulation 8.2 says that any self-incriminating answer will not be admissible in evidence in criminal proceedings against that person except on a charge of perjury. Chair, you will well know with respect that the constitutionality of those provisions has already been engaged by the Constitutional Court. In its 1996 Ferreira versus Levine decision, it looked at the equivalent type of provision in the insolvency context, and it determined that while there was a limitation to the fair trial rights of the witness who may subsequently become an accused in criminal proceedings, it was nonetheless a reasonable and justifiable limitation of their right. And the reason why is because there is a hefty public interest in that context in insolvency in unearthing what happened inside a company where people are only third parties to the company and may have claims against it. The Constitutional Court ultimately concluded that the balance there meant that the public interest in the pursuit of truth, provided the compelled answer was coupled with a use immunity, was sufficient to survive constitutional scrutiny. And we would submit a similar legal position obtains in Regulation 8.1 and 8.2 in these proceedings, because they are replicas of those provisions which the Constitutional Court found to be constitutionally consistent in Ferreira and Levine. Chair, finally, just in terms of the themes of the evidence that you will hear over the next 2 weeks. Chair, the evidence appears to indicate 5 themes about not only what happened in the last many years in this country, but what the enablers were for state capture, corruption, and fraud in the public sector. That topic is squarely within the mandate of the Commission. And one of the things we have searched for in the course of this investigation is, well, what are the key enablers of that type of conduct taking root and permeating our public institutions? Chair, you will, of course, in due course make the final determination as to what the evidence shows in relation to those. But at the outset, we thought it appropriate to highlight 5 potential enablers, what we call the facilitators of malfeasance in our systems. Chair, the first of those is when priority crime investigations stall for unthinkably long periods and are not brought to resolution.
Is that the Hawks?
That is the Hawks, indeed.
Yes.
In this case, you will have a report from the Hawks that shows that for 2 years, they were getting bank statements from a single bank in relation to a single company that just does not stack up as the product of diligent investigative and prosecutorial work. That is an enabler because it results in a situation where perpetrators are not brought to justice in any reasonable stretch of time. The second, Chair, is companies who allow their businesses to be used to hide the proceeds of unlawful activities. When they do so, they facilitate theft of the public purse. And so they are a second enabler of this type of conduct. Chair, the fourth is funding institutions who are not rigorous enough in their funding decisions, and as a consequence of which, end up handing out money to those who should not receive them, and ultimately, in this case, to a beneficiary who was within the IDC at the point in time. Chair, the fourth enabler is ministers who sit in the Department of Public Enterprises and retain members of boards in their positions despite sustained evidence that they are not complying with their fiduciary duties and who do not act swiftly enough to ensure proper governance within those state-owned enterprises. And Chair, the fifth, and the one that brings us focally to the evidence of today, is when ministries who receive whistleblowing reports from people who are trying to stand up to the assault within SOEs do not act on those whistleblower reports. The consequence of that, and you'll hear it in the evidence today, is that civil society organizations have to step in, but they have limited funds. They aren't available to everyone at all times. And there's a concerning respect in which the attention to and the response to whistleblowing action in the course of the evidence you'll hear seems to be somewhat wanting. Chair, those in our submission are 5 of the enabler themes that you will hear over the course of the 2 weeks of this evidence. And Chair, with that background in place, if I could just deal with the files and how they're arranged for the purposes of the evidence. Chair, we are now in what I'm told, on good authority, is Exhibit DD in the sequence.
Yes.
Now, yesterday I'm also told became EE, but that's because of an unusual arrangement in the scheme.
Yes.
All of the aviation evidence will be Exhibit DD, and then each of the witnesses will follow in the sequence from 1 to 16. Chair, today you have 3 files of evidence for Ms. Stimpel's testimony. They are arranged A, B, and C, and I will indicate at any point which of the files we are in. Chair, you also have a copy of the cross-examination applications that have been received by the former CEO and CFO, but I've already indicated our proposal for how that aspect is managed in the course of the evidence.
Yes.
Chair, that brings me to the end of the initial background opening remarks. We have Ms. Stimpel here, and she's ready to give evidence, if that's suitable.
Thank you. Does Mr. Zwane wish to place himself on record, or
Indeed.
does he wish to just be present? Mr. Zwane, come forward and tell me whether you want to place yourself on record or whether you just want to be present.
Good, thank you, Chair. Indeed, with your leave, I would like to place myself on record on behalf of Ms. Stimpel.
Yes, please do so.
I am a practicing attorney from the law firm Zwane Incorporated Attorneys. We are based in Sandton.
Yes, and once again, you represent who?
Ms. Cynthia Stimpel, the first witness this morning.
No, thank you very much.
Thank you, Mr. Chair.
Thank you. Okay, Ms. Hofmeyer, the liver art file which contains the evidence, the statement of Ms. Cynthia Soraya Stimpel will be marked Exhibit DD1A. Marked Exhibit DD1B, and the third one DD1C. And oh, was I not on record? The first one will be marked Exhibit DD1A, that is the one that contains Ms. Stimpel's statement. The 2 other liver arch files will respectively be marked Exhibit DD1B and DD1C. And we don't need to have these marked, the small ones, yeah.
No, Chair, that won't be necessary.
Okay, thank you, and thank you for that opening statement. Yes, please administer the oath or affirmation.
Please state your full names for the record.
My name is Cynthia, Agnes, Soraya, Stimpel.
Do you have any objections to taking the prescribed oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you solemnly swear that all the evidence that you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you. Yes, you may proceed, Ms. Hoffman.
Thank you, Chair. Ms. Stimpel, you would have heard my indication to the Chair about the files that appear in front of you. Just so that you can orientate yourself, there are 3 files which comprise your evidence. The one open in front of you is file A, and then you will see B and C are also available to you. When relevant, I will ask you to move between those files. Ms. Stimpel, there are a few corrections in relation to your affidavit that you've brought to our attention. My proposal is to deal with them as and when they arise in the course of your evidence. I have made a note of them, and so I will direct you to them at the relevant page when we are there in your affidavit. My proposal for the course of the evidence, Chair, is to move pretty much in line with the development of the affidavit.
That's fine.
Ms. Stimpel, the first correction, however, appears on page 1, and it is in fact in the spelling of your name. Could you please correct that for us for the record?
Yes, it should be Stimpel.
Not LE as it appears on page 1 of your affidavit. Is that correct?
Yes.
I'm sorry, just repeat that spelling.
Stimpel.
Oh, okay, thank you.
Chair, you will see in due course many of the Rule 3.3 notices even went out with that error because
Yes.
we were working on the name as it appeared here. But we do
Yeah.
apologize for that error, Ms.
Yes,
Stimpel.
no, that's fine, and maybe a new copy can
Yes.
be, of page 1 can be arranged.
Indeed.
And then what's written on the spines, all this one is written correctly.
I think we caught it in
Yeah.
time for the spine labels.
Okay,
But
okay, all right, thank you.
Thank you, Chair. Ms. Stimpel, I'd like to begin, if we may, with just some background to your employment and credentials in relation to your studies. Would you give the Chair some background as to that?
Thank you. I have an MBA from the highest qualification is an MBA, and I've also got certified director, which I studied recently. From an experience perspective, I started working in the bank, and then in 1975, and I have over 35 years of banking experience, having worked in various retail and merchant banking with Citibank at the time, and then corporate banking, and then worked at DBSA, which is development funding, and my last 10 years of my career was spent at SAA as the head of financial risk manager, and the last year and a bit was as partly acting group treasurer and then as group treasurer. Thank you.
Thank you. If you turn over to page 2 of your affidavit, Ms. Stimpel, you have a heading there entitled The Boards. And under that section of your affidavit, you deal with your experience of different boards while you served at SAA from 2006 to 2016, as I have it. Could you please tell the Chair about your experience of those different governance and management styles as a result of the board's different composition over time?
With the earlier boards under Ms. Cheryl Carolus and Mr. Richard Laubscher and others, there was a focus on them wanting the company to work, ensuring that we work on a strategic direction for the organization and that the entire team of SAA work together towards this vision. And I recall that time being quite positive for SAA, even though SAA had come out of doldrums. They've always been in some problems, but there was energy in the organization and the focus was willing to make it work. Ms. Caesar Mtsimela had come in then also as the CEO, and she worked with each different department, also trying to understand where the issues were and how we can get SAA working as a coordinated organization and make sure that we do achieve the strategy and the vision of the organization. Subsequent to Ms. Carolus leaving and part of the board leaving at the time, there was constituted a new board, and obviously we got a few acting CEOs over the time. And then what I noted then is that there was interference from our board who directly wanted to know about certain contracts. The way we operated is that each division was responsible for a specific activity or business role, which then you had to go from a corporate governance perspective to the board for approvals. And this somehow the change was that the board was directing how the procurement should be going and where it should be going. Thank you, Chair.
Ms. Stimpel, you then at page 3 take up the topic of debt consolidation, which is really the subject matter and the focus of the evidence in this first part of the session. Could you please explain to us what the debt position was and really the financial precariousness of SAA around the time February 2015, which is where you begin at paragraph 12 on that page?
So at that time, SAA we had government guarantees of up to about 14 billion at the time, and we had borrowed roughly about 11 billion. However, our borrowing was always short-term, meaning that when they came up for maturity, they had to be rolled over. And it wasn't a simple process for us in Treasury to do that. One had to, as the loans were coming to maturity, we had to write a submission to board to ask permission to state that these loans are now maturing and that we're going to roll it over. Board would give us the approvals, and then we would roll the debt over. Obviously, at that time of continuous rolling over debt, being short-term, you pay a higher interest rate. You're also then in a continuous cycle of having to repay debt. You've got 3 months, you've got 6 months, you've got 1 year, and before you know it, the months have passed, you have to roll over the new debt, and you have to roll over the new debt. So we were always in the cycle, constantly busy doing these submissions to get the debt going.
Thank you. You say in paragraph 12 that in February 2015, you were appointed as the acting group treasurer after the resignation of Mr. Petolo Ramosabudi, who went to work for Transnet. Can you tell us about your occupying of that position? And with particular reference, if I may, Chair, this is the first point at which one of the allegations against Ms. Stimpel is relevant from the cross-examination application of Ms. Nhansi, who will come next week to give evidence. She criticizes you and your lack of experience as a consequence of only being appointed as acting group treasurer in February 2015. What is your comment in response to that?
Okay, so I started at SAA December 2006, And in March 2007 was when we first borrowed 1.3 billion from Nedbank as SAA. And SA received a guarantee, a government guarantee from National Treasury at that time. Subsequent years that followed, SAA kept borrowing, so we needed to get new government guarantees and then borrow funds from that. My role as head of financial risk was always being involved, A, with the funding, and B, I deputized for whoever the group treasurer was. So when I started there, Ricky Thurian was the group treasurer. He resigned in the middle of 2007, and I deputized for roughly 6 months at that time. A new group treasurer was appointed, and whenever he was away, I deputized for him, and when he resigned, I deputized for him. Subsequently, a new group treasurer came in by the name of Lawrence van der Merwe. I also deputized for him. In fact, when I presented at board, I presented at EXCO, at audit and risk committees on his behalf at times, especially from a hedging perspective and on the financial side. Subsequent to Lawrence resigning, we then brought in Pitolo, and even then I deputized for Pitolo. After Pitolo resigned is when I was acting, and because at that time SAA had also gone through a reduction of staff earlier, about a year or two earlier, and had to go on a process of finding staff that are skilled within the organization and employ them. And that's how I got employed as group treasurer of SAA. I went through a full process of interviewing panels, etc., and I was then chosen. You mentioned something else.
Yes, just in the lack of experience is really where the nub of the criticism lies. What is your response to a lack of experience in the role of group treasurer as a consequence of only taking up the position of acting group treasurer in February 2016?
So I feel that I've had the experience having been 10 years at SAA. Secondly is that I've worked in banking my entire career, and I've worked in a treasury environment. So I know how the treasury environment works. I know how we need to source funding. I know how we manage the risks around the hedging processes, and I also managed the risk there for the 10 years at SAA.
Thank you. At paragraph 13, you talk about a clash between the DPE and the board. And you also then go on to deal with the movement of your reporting lines between the Department of Public Enterprises and National Treasury. Can you tell us about that? What was happening at that time?
So in previous years, SAA, all state-owned enterprises report to a ministry. And SA reported to the Department of Public Enterprises at that time over the many years. And then during this period, there was Mr. Gigaba and there was Ms. Lynn Brown that we had reported to. And suddenly there was a change. We were told that we will no longer be reporting to DPE, but rather directly to National Treasury. And our process and our working relationship with Department of Public Enterprises at that time was to have monthly meetings on reporting on certain activities and quarterly meetings on the whole organization, reporting where we were financially, where we were with the strategy, etc. And with National Treasury having come in, SA was in a crisis situation at the time, and they directed us to say we will meet on a weekly basis, in that we try and solve the problems that is creating the crisis for SAA, which is A, the financial side, the B was on the Airbus deal, and then there were various other areas. And so we met with them on a weekly basis and on a monthly basis as well. And then there was the full quarterly, which responded to the full turnaround strategy and the vision of the organization.
Thank you, Ms. Stimpel. I've been asked to request that you bring the mic slightly closer to you so that we get an accurate record for the transcription. Ms. Stimpel, if you then move to page 4 of your affidavit and paragraph 15, you there talk about your first task being to write a borrowing plan. Can you explain to us what that involved?
Thank you. I was given the task to draw a borrowing plan because SAA in the past have gone to National Treasury and via DPE at the time, Department of Public Enterprises, to get government guarantees, and on the back of the government guarantees, we went to the bank to borrow funds. However, we never had a formal borrowing plan like Transnet had or Eskom had, and National Treasury directed us to draw up this borrowing plan and see how we can manage our funds, and also look at, they wanted 3 to 5 years. They said we would keep coming, which was true. We were coming there on a regular basis every year wanting to borrow, but we had no future plan ahead. So that was my task, to find out what we needed for SAA. What I did was I did some research through Transnet's borrowing plan. I also did it through various others, state-owned companies. I looked at DBSAs and then see what would be a best fit for SAA. I drew that up. I shared the knowledge within our team. We have a financial risk subcommittee that we look at all financial risks within the organization, and the borrowing plan would form part of that. So it went to them for review. And thereafter, I sent it to my boss at the time, who was Mr. Wolf Meyer, and he also gave some constructive criticism of it. Then we sent it to National Treasury to give a review and add any changes that they would like to. They subsequently did do that. They sent it via email, via track changes. And once we did that, we then put it through to our EXCO committee and our corporate governance levels, which would have been EXCO Audit and Risk Committee and Board. Board subsequently approved that in April 2015. Thank you.
Thank you. Could we just focus on paragraph 17 on that page, because you summarize there what your analyses showed during the course of your devising of the borrowing plan. Can you explain to us with particular reference to the saving that you reference there?
Thank you. So if we looked at our total maturity, debt maturity profile, we had various debts maturing at different periods and different rates and short term. And we looked at, if we borrowed longer term, for instance, taking a 5 to 10 year tenure and take that full debt of 15 billion, or which was our guarantees, which was at the time roughly 14 odd million, but we rounded the number up to 15 billion. And we did a calculation that if we did that 15 billion over longer term, 10 years, at a fixed rate, and we worked on the JIBAR rate at the time, because that's the rates that our banks quoted us, we would have saved approximately roughly 400 million. And that was our calculation on it.
And you mentioned at the end of your previous answer that the borrowing plan was submitted to the board and that it was approved by the board, as I have it at paragraph 18 there, on the 22nd of April 2015. Is that correct?
That's correct, yes.
Now, at paragraph 19, you give us a bit of background as to the nature of funding decisions within SAA, as contrasted with procurement that is governed by the supply chain management policy. Could you explain to the chair what the distinction is that you draw between those two areas of decision making?
Thank you. With SAA and through our borrowing process, we followed the financial risk management policy. And there's a section in there which covered the funding. And in the history of SAA having borrowed funds since 2007, we've borrowed funds directly through the banks. Yes, we did follow an RFP, but it only went to the 5 major banks at the time. The amounts were huge. Our first amount in 2007 was roughly 1.3 billion. And subsequent to that, they were similar amounts. The reason why we chose the banks, because they were our relationship supplier for funding, and they could supply funding. We knew that. The SM policy, which is the supply chain management policy of SAA, always focused on the supply chain. So any vendors or any other activities that SA was involved in, that's where the policy complied with. As SA Treasury, we didn't go through the SM policy for funding. And so when it came to this transaction now, this was the first time that the BNP transaction had gone through the SM policy. But historically, SA followed the financial risk management policy, and even when one went through our process, we went through the financial risk subcommittee. From there, it went to EXCO committee. From EXCO, it went to audit and risk and board, whereas the SMP policy went through firstly a CFST, which is a cross-function sourcing team, then it would go to the bid adjudication committee, and then only it would go to audit and risk and board. In fact, there was another committee called FIPCO, which went into that, and it didn't follow the route that the financial risk committee went. Thanks.
Ms. Stimpel, how, if you weren't using the supply chain management policy for these funding pursuits of SA, how would you ensure competitiveness in your approaches for funding?
Because we only used the banks, and we used the 5 major banks, we didn't even attempt to try Capitec, which was a new bank that came on. We knew the history of the other banks. They were solid, and they could borrow huge amounts, at least lend huge amounts to corporates and to state-owned companies. And if one looked at the entities like Transnet, DBSA, Eskom, the banks were involved with those. Transnet, in its sense, in its own, could go into the money market and issue its own bonds. SA was not at that level yet to issue its bonds. So for the best method for SA at that time was to go to banks and seek recourse and funds from them.
Did you chase competitive rates from the banks?
Oh, yes, we did. And that's why we went to all 5, and we would do a full analysis on each of the banks, what they offered, before we made our final decision. Correct.
If we then go over the page to page 5 of your affidavit, I'd like to pick up the point at paragraph 24, because as I understand your evidence until now, you devised a borrowing plan, you took it through the various levels for approval, both to Mr. Mayor, the then CFO, you got National Treasury's input, it's then placed before the board, and the board approves it on the 22nd of April 2015. But what you start to deal with at paragraph 24 on page 5 is concerns being expressed by the board of SAA at the time about the process that you were embarked upon. Can you tell us about what those concerns related to?
So what had happened is that after the borrowing plan having been approved, and in our discussions with our then CFO, we were having maturities come up again of our loan book, and we needed to go out and borrow again, or roll over the debt, which was the other alternative. And we then used that opportunity to go out and see if we can do the debt consolidation, see what prices the market could offer us, what the banks had, if they had the appetite for 15 billion, because most banks wouldn't just go out and put the entire risk on one entity, and they would try and manage that risk. So we went out on an RFP for 15 billion at the time. Our board then was very up, because what happens is we've got to put the information back to board, and they were uncomfortable. They said, why are we going out on debt consolidation? They're unaware of the debt consolidation. It's never been approved, and can we write a paper on debt consolidation?
Let's go, if we may, to the actual email that you reference at paragraph 24, because that's an email that comes from the then member of the board, Ms. Yake Kwinana, and you will find it at page 170 of the file in front of you. That is Annexure 3, Chair. It should be under that tab, and it's page 170. It commences.
Thank you.
Have you got page 170?
Okay,
Ms. Stimpel?
I'll find it. Thank you. Yes.
Can you tell us what that email is and what it deals with?
Yes, so this was when we had gone out and put out the debt consolidation process for the first time, and then Ms. Kinana had come back to the CFO, the then CFO, saying that we should follow proper processes and that we should cancel the tender. So we had gone out already on that, trying to elicit information and to sense the appetite of the potential funders, which were only banks at the time. And she writes there that we didn't follow the processes and that it needed to be cancelled.
And in the second sentence there, as I read it, she's querying with Mr. Mayor how he determined which funders to approach. And if you close it to selected funders, she queries how are other new entrants expected to participate in South African Airways. Did you understand that to be part of the concern at the time, that your pool of recipients for the RFP was too limited?
Yes. We always felt that we should be going to banks because the banks would have the capacity to lend such huge amounts. Even the banks borrow from a Sanlam and an Old Mutual. We wouldn't go directly to those institutions to borrow funds, and we didn't add any others because we felt that they wouldn't have the capacity to be able to fund SA. But yes, that was a concern.
You responded to that email of Ms. Kwinana's, and that is over the page in the next annexure at 178 of the file. I'd like to pick up a few points to emphasize in relation to your response. You deal in the third paragraph with the background to the RFP, and you say there, and I quote, "The reason the RFP was sent out at that time was because the chairperson had instructed the CFO to send the RFP out, and he in turn instructed the Treasury team to send it out. We sent the RFP on the Friday, the 26th of June, 2015. Is that your recollection of the events, that there was in fact approval for this RFP to go out?
Yes, we got our instruction from the CFO to go ahead and send it.
And you go down at the 7th paragraph, which is just below the middle of the page, to talk about the utility of sending out the RFP. And as I read this in general terms, Ms. Stimpel, and you'll correct me if I'm wrong, it reads as though a response to the board in which you're trying to motivate for the sense behind the process that you've adopted and to try and dissuade them from cancelling the RFP. Is that a fair summary?
That would be a fair summary. I felt that the company's reputation would be at risk. So if you go out and put an RFP, then you withdraw it, and you come back later and produce another, and you withdraw it, the banks would look at you and saying, can't you manage your finances? And so I was looking at it, yes, it was out of concern for the organization and its reputation.
Towards the bottom of that page, you deal with this question of new entrants. It's your penultimate paragraph there. Can you tell us what your comments were in relation to Ms. Kwinana's query, that it shouldn't be confined and that it needed to be expanded to, quote, new entrants on the funding spectrum?
Yes, so we primarily only went to the banks, mainly because they kept everything confidential, and we didn't open the RFP to any non-banking institutions, even though we knew about the Sanlam or the old mutuals. And with the email that we received from Ms. Kwinana stating that have we considered any new entrants, in my response then to board on this was that if we go with new entrants, we don't know how confidential they'll be regarding the information and the sensitivity of our information. And so that was my concern, which I put out there.
Over the page, however, at 179, you do record some of your experience around that time, which related to receiving unsolicited approaches from non-banking institutions, despite the RFP being confined to the 5 banks. Can you tell us about that? What was happening at the time?
Correct. So we were getting calls. Actually, they were firstly going directly to Mr. Mayor, who then called myself and Michael Klein in, who was the head of cash management. And we set up meetings with them. People came in, many from different organizations, all different business cards, all wanting, saying that SAA is seeking funding, we can help you. And when we told them the quantum of the amount being 15 billion, some of them said, we can do it, and others said, oh, that's too much. But those that could do it was, some people couldn't even, we said to them, then send us a term sheet. We're going to put an RFP out, respond to the RFP, and send us your term sheet. They asked us, what is a term sheet? So that was the level when I realized they don't even understand how to manage funding, how to put forward a proposal of how you're going to express the amount, the duration, the term, the tenure, the interest rates, etc., on the term sheet. And we had many of these discussions over time, which we felt at the time was a waste of our time. We were trying to get the funding going, and now we're being held back by having to speak to individuals.
You raise a concern in the second paragraph on that page about how these entities even got knowledge of the RFP letter. What did you make of that at the time?
Yeah, I was surprised because I asked Bob, they were calling his number mostly, and I asked him, how do they know? Because we are responsible for it in Treasury, and we sent it out only via email. So how would they know? And he said it could come from the board. Those were his words. And I would suspect they were the other ones that knew, or it was the CFO or any in our exec team. But the exec team have been there at the time long enough, who have never then disclosed information on our borrowing, because we've been borrowing since 2007. So the summation I made, and at the time, based on what Wolf Meyer told me, that he suspects it's from the board.
And where does this culminate? Ms. Kwinana comes in and says to Mr. Mayor that she's dissatisfied with the process that's been followed. You are told that there's an issue that they want to broaden the ambit of those who have been formally provided with the request for proposal. Mm-hmm. What then happens? And you may make reference to paragraph 26 on that page, because it seems from that paragraph that Ms. Mieni and the board then took matters further.
Yes, we then had to cancel the RFP, which we did. And we then put, because the funds needed to roll over, we put in another submission through to the normal process of FRSC, audit risk, and board. And this time we only put in an amount of the amounts that were due to be rolled over, which is roughly over 6 billion. And so we put a round number of 7 billion, which we're going to roll over. And once it got to our board changed the board resolution and changed it to go out and do 15 billion debt consolidation.
Ms. Stimpel, we'll go through that if we may in some detail, because I'd like to look at the documents relevant there.
Yeah.
But if we could just go to this email communication between Ms. Mieni and Mr. Mayor, you'll find it at page 181 under tab 5, which is the relevant annexure number.
Yes.
You'll see there, the bottom of the page is what I understand to be the first email from Ms. Mieni to Mr. Mayor, and then his response at the top. Could you just indicate to us what Ms. Mieni is saying in the second half of that page in her email on the 16th of July, 2015?
She has written to Mr. Wolf-Meyer, the then CFO, stating that the board has decided that they shall withdraw the RFP for long-term funding and that they will need to get formal paper on the debt consolidation if this RFP is aimed at addressing the same.
Ms. Stimpel, can I just stop you there? Had the board not received anything from you at this point about your planned debt consolidation?
They had received the borrowing plan, and I did write a document on debt consolidation and explained did the comparisons that if we stayed rolling over debt, we incurred this interest continuously, and if we consolidated our debt, we would be saving, and we would have less stress in the organization, always running for every maturity and trying to find out how we're going to roll over the next maturity.
So what do you make of a request now for a formal paper on that which, as I understand your evidence, you'd already provided?
I don't think they read it. Otherwise, I'm not sure why it was brought in again.
And if we go to Mr. Mayor's response at the top, you'll see he there says, "Dear Chair, following the decision of the board to withdraw the RFP, we have formally in writing advised all the recipients of the RFP that has been withdrawn. We shall work on and provide the board with a formal paper on debt consolidation as a matter of urgency." Did
Which
you
was
follow
done.
through with that?
We did, yes.
And so that would have been your second paper, so
Yes.
to speak, on debt consolidation. Thank you. I'd then like to move to that process which you summarized for us a moment ago. Let's go first of all to the Audit and Risk Committee's recommendation to the board. That is Annexure 7, and you will find it at page 203. Can you talk us through this decision record of the Audit and Risk Committee, which is dated 24 August 2015?
Thank you. This, as Treasury, we would do submissions through the various corporate governance levels, and this particular one had gone to Audit and Risk Committee. And that was when our loans were maturing and we had the 7 billion amount which we were going to roll over. And we stated there the funding requirement for August of 1.5, funding requirement for November maturing 2.5, and then because we had the general short-term banking facilities, which was our overdraft we had with various banks at 1.3, and then Nedbank. So the total was roughly about 7 billion. This was the submission that went through the FRAC, which is the Financial Risk Subcommittee, and then it went to the Audit and Risk Committee. At the Audit and Risk Committee was when the board changed the board resolution, because this decision record is a board resolution, at least the Audit and Risk Committee resolution, whereby they state and change the amount. If you turn over the page, Chair, on 204, you see that it was changed to 15 billion. And in that, the board members who sit at the Audit and Risk Committee, and the same board members also sit at the full board, stated that we should put out an RFP for 15 billion, and that the board as a whole and the acting CEO should be included in the process of issuing an RFP.
Could I just pause there?
Yes.
Was that customary?
No. That was the first time I've seen that, because you get a directive. Board's role is oversight, that they will obviously have the best interest of the organization at heart and direct management of what to do and how best to do it. But they don't go to the level that they want to be involved in an RFP process. They could have directed and say, include external parties or broaden your RFP, but they wanted to be involved and they wanted to add on additional parties. So once we did the RFP, we had to send it to board, and they then added on interested parties, which we had to then send the RFP to.
Well, let's
What, I'm sorry, what did you understand this request or directive or instruction to mean, that the board wanted to be involved in the RFP? Did that mean they wanted to be involved in the actual formulation of the RFP? What exactly did it mean as you understood it?
How I understood it, because I did see clarification from our company secretary's office, asking them how do they want me to proceed, and they wanted me to write the RFP. Once I've written it, I had to send it to board. Board needed to review it. I also had to list the clients that we were going to send it to, the service providers for funding, and send that to them. And they also instructed that we use previous suppliers that we had on our list from February already, from earlier time. So it wasn't only the banks, it was all those other funders, potential funders who had come to SAA unsolicited, seeking to assist through financing SAA. And so my understanding was that nowhere before did an RFP document go to a board first for approval. Not anywhere, not even the supply chain management process. So we had to send that to board. Board then approved it with the list, and we subsequently, through Dr. Tambi, received a couple of other clients which we needed to add on to the list, and only then could we send out the RFP to the suppliers. Thanks.
Chair, if I may ask Ms. Stimpel to go to two of the documents which will actually show you that list and the draft RFP that was sent. Let's start at page 207, because 207, as I have it, is the CFO's document that goes to the board, seeking the board's approval. And you'll see under item 1 there, it says, well, proceeding that the purpose of the submission is to, 1, request the board to approve the RFP for financing of 15 billion, Annexure A. And if you go over to 210, which is under the next tab, I take that to be the Annexure A that they were asked to approve. Is that correct?
Correct.
And then if you go back to 207, you'll see the second thing is that the board was asked to confirm the list of counterparties to be included in the RFP. And then if I can ask you to flick over to 212, is that the Annexure B referred to?
Correct.
Okay, so let's go down on the page at 207 just to understand what the board was resolving here. You've made the point earlier that there was already a change at the Audit and Risk Committee of the 7 billion that you had proposed was required to source to a 15 billion. And you see that reflected again in the board's request under A, under 3, sort of below the midway of the page. Issue an RFP for the long-term funding to banking and non-banking financial institutions as per Annexure B for the financing of a total amount of 15 billion in order to consolidate the current debt portfolio of the company. Is that what the board then approved to do?
Correct.
And then you'll see under D, this point is picked up again about who is going to determine who the recipients are of the RFP. D records, ensure that the RFP is limited to the counterparties that responded to SAA in the February 2015 RFP. Now, can we just pause there? That's the RFP that you were told to withdraw.
Correct.
Right. So now they want this RFP that they have approved to go to those very same institutions, as well as other institutions that can be recommended by the board members and attendees. Is that correct?
Correct.
So let's go to the list and let's look at who we have there, if we may. That was at page 212. So tell us about the compilation of this list. You indicated that it would include those who had responded to the February 2015 RFP, and then others. Where did the other suggested entities come from?
Okay, so the first 5 are the banks we normally deal with. The Deutsche Bank and the others, well, I won't say the first 5, there's various, but not everyone responds. So there's the banks that come in. We opened it to broader banks, which we don't normally do, like your Goldman Sachs or HSBC or JP Morgan, because they normally wouldn't lend directly to SA. They would perhaps fund like aircraft or other initiatives within SA or other needs. But they were our clients as well, and so we opened it to them. The latter part, the ones, the non-banking financial institutions, for instance, the Batho Malile Holdings, these were all new clients to us. We met them all over the time of them first coming for unsolicited, or at the time of the RFP sending in information, or just giving the names to either Mr. Mayor or via Mr. Dr. Tambi, and those is how we managed to put all these together.
And then what happened? Did you act in accordance with the board's decision?
We then did. We sent out the RFP. We sent it only to those on this particular list that were there, and we gave a timeline for them to respond to the date we gave them. Our closing date was the 2nd of October to respond to the RFP, and that gave us time then to analyze all the term sheets once we received them, then we normally put it in a spreadsheet format where you list each of your clients and you list the amounts and the duration and the interest rates that they prepared to fund SA, and that made it into a summary, and then we wrote our submission of who we should choose. We normally look at who is the best client that offers you the best interest rate and would then offer some interest relief for SA.
Thank you. Before we get to the details of that evaluation, I'd like to deal with page 6 of your affidavit, starting from paragraph 33, because there you record what Mr. Mayor at the time recounted to you about a meeting with a potential funder. Chair, Mr. Mayor is not scheduled to give evidence in this evidence session, but is more likely than not going to give evidence in the second session. So to the extent that there is any aspect of hearsay evidence here, we would ask him to assist us on that. If it becomes such that oral evidence is not required, he can of course also provide an affidavit. But what is important is what Ms. Stimpel does in these paragraphs, as I have it, is recounts what you were told by Mr. Mayor about his meeting with the potential funder. Is that correct?
Correct.
And tell us about that. What did Mr. Mayor tell you?
Yeah. So we were called in. We were direct reports, obviously. So from a treasurer perspective, you would call myself and Michael in, or Lindsay or whoever else. We were called in as a team of managers at the time. He raised his concern about the funding. He said that he's been called to a meeting by one of the potential funders on this list, and he went to the meeting. Obviously, he thought they're going to discuss the maximum amount they could offer, or anything like that, or they were struggling with how to complete the term sheet. He went there and he said he was told that they must ensure that SAA gives this client the deal, because number one wants this deal to happen. I frowned and asked him, what do you mean? And he did explain, saying that he was in this room, and he understood that number one meant to be the president at the time, Mr. Jacob Zuma. The client then was Mr. Jayendra Naidu, who worked for, I think the company was either First South, because they were the financial institution at the time, and they're on this list. If you look at the list here, First South, financial services.
Just to be clear, as I read what you have said here, at paragraph 33, you indicate that Mr. Naidu was present at the meeting, but you go on and say he, Mr. Mayor, was called outside by one of the men present. It's not clear to me that that's necessarily Mr. Naidu. Is that correct?
Yeah.
Thank you.
That's the name.
And then...
I'm sorry, does that mean you didn't ask him who the person was that called?
No, I didn't.
You didn't, and he didn't offer the information?
No.
Okay, all right.
Thank you.
At paragraph 34, you indicate what Mr. Mayor said in response, or at least what he relayed to you, he said in response. What was that?
That he wasn't part of the contract. I mean, he's not part of the decision making because it's done outside the CFO, and that it's done in a team, and obviously a full analysis is done, and so he couldn't play a role in it.
And then at paragraph 35, you talk about the fact that he relayed to you that he'd recorded the conversation. Tell us about that, if you will.
Yes, he said he had his own personal reservations when he went into the meeting, and he had got himself a pen which he could record with, and he had it in his pocket when he went into the meeting. So he said he had recorded the full meeting. He only told us, who were in his office at the time, who had called to this meeting on that morning, and I still said, well done, on it. So, and then we left because we had work to do.
And whenabouts in time was this? Can you recall? When did he give you this feedback about the meeting?
I think it was around October.
2015?
Yeah, 2015, correct. Yeah,
Okay.
Before he resigned. He resigned in November.
Right. And then I'd like to pick it up over the page at paragraph 36, because that recording pen has some later significance.
Correct.
What do you recount at paragraph 36 there about the circumstances preceding Mr. Mayor's departure from SAA?
There was a board meeting held, and they sometimes it was separate where only the board members attended, and they excluded Mr. Mayor, and at the time I think Nico Bezuidenhout was acting CEO. And after that sort of board meeting, they then called Mr. Mayor. When they called him, he was then searched by the security. His pen was taken from him, and he had to hand in his laptop. I think he had to hand in his laptop. But they had taken his pen at the time from him by the security guard as he entered the meeting.
Can I just ask about that process? Was that usual, that people would have to part with their laptops and pens and other devices when they went to attend board meetings?
It was most unusual. That's the first time I heard about it when he told us. And we even made a joke later saying, go into meetings with a pencil and not a pen, And but subsequent to that, there was a meeting that Ms. Mayene called to all attendees at National Treasury in February 2016 when we attended there, and also when we came in, there was someone waiting at the door, and she said, hand your computer and your cell phone to this person, and then only we could come into the boardroom and sit down. So that was the first time I've seen that. Even at National Treasury, I've been there for many meetings. I've never had to hand in. Obviously, you go through a scanning process, but I never had to part with my laptop or my cell phone.
What did you make of that instruction at the time?
I found it very unusual, and I found it, for me, there was a suspicion, how did they know that Mr. Wolf had a pen which could record and then took it, and we would take a ball pen from your pocket. So that was a suspicion. Secondly is, I felt that when there was obviously something not right going on, that you start meddling with people's cell phones or and you don't want people to record your conversation or use your laptop for whatever reason while you're in a meeting. Thanks.
The persons to whom you had to hand over these devices, do you recall who they were or what status they had?
They were security. I don't know them because they're not familiar to our normal standard security that we see at SAA. You get to know them over the years and you get to know them by name. Fortunately, I normally don't go in with my cell phone or my laptop, so I didn't have to. They just asked me, do you have anything? I said no, and I walked through.
So just to be clear, were they not SAA regular security personnel?
Not that I recognized them, no.
And you can't assist us any further as to where they may have come from?
No.
Thank you.
Sorry.
You then go to paragraph 37, where you record that Mr. Mayer left in mid-November 2015. What were his circumstances when he left?
Prior to that, there was some article in the newspaper regarding Mr. Mayer. We had some trapped funds, we called it trapped funds, within Nigeria, Angola, and in Africa. In that, because of the oil crisis, remember the price of fuel had gone down to $50 at the time, and Nigeria and Angola were suffering from it because they also, besides using their own domestic currency, they were also using the dollar as their legal tender within the country, which impacted them on their entire operations. The impact for SAA and many other airlines was that we couldn't get funds out of the country either. And so there were these trapped funds, and he was accused that he wasn't managing these trapped funds efficiently within Africa, but it was written in a negative light. And he then had also called us a subsequent meeting to that, saying that he had gone to see his lawyer about it, whether he should challenge this, because it was just out there in the paper, which was defamation to his career and his character. And his lawyer had advised him to walk away and resign. And so he had told us, and only heard that on the day he told us he was resigning, telling us because of what had happened, we'd gone to, I'd gone to my lawyer, he advised me to resign, and I find it safer, and so I'm going to resign, and I have already found a subsequent employment.
And then at paragraph 38, you record who Mr. Mayer's replacement was. But that is one point at which I have a note that there's a correction that you want to make. The sentence as it reads currently is that Ms. Pumeza Nancy replaced Mr. Mayer as the interim CFO at the beginning of December 2015. What is the correction you'd like to make there?
I've confirmed after this, so my apologies that it's December, but it was the 27th of November when she started.
Thank
I'm
you.
sorry.
2015.
What was the date?
The 27th of November 2015, when Ms. Pumeza Nancy started at SAA as interim CFO. Yeah. I put
Okay, thank
beginning
you.
of December because that's when we met her.
So we'll change beginning of December just to correctly reflect 27 November 2017. Is that right?
Correct. Thank you.
Chair, we're about to move to a new topic, and I see we're just in advance of the tea time. Happy to take the adjournment now if that suits you, or we can continue.
On mine, we have 5 minutes more. I don't know if it's correct. Is yours?
Mine is 5, but I was moving to a new topic, so I thought we may want to break. Otherwise, we can proceed until...
But our watches, are they on the same
They
time?
are on the same. I'm also at 10 past 11.
Okay. No, let's use the 5 minutes.
Excellent.
Okay.
We then start in your affidavit with a topic-headed responses to the RFP. So just to orientate ourselves, because we had a bit of an interlude with Mr. Mayer's call to the particular funder, At this point in time in your evidence, you've had approval of the RFP that had to go before the board to source 15 billion rands worth of funding. They've approved the list and you've gone out. You've issued that RFP to that list that we saw Annexure B at page, let me just get it again, page 212. Is that correct?
Correct.
And now you enter a part of your evidence in which you talk about the responses to the RFP. Can you take us through, at paragraph 39 on page 7, from whom SAA received responses to the RFP?
So not everyone responded to the RFP, and we received it from a few banks, and the main client that was able to supply the full 15 billion was Seacrest. The other client was Confetti, Innovex, Hammerschlag, Standard Chartered, ABSA, and Nedbank. Those are the ones that the others didn't fit in that we got, but these were the main respondees that we got from the RFP.
1 second.
Yes.
Sometimes your voice seems to be low, sometimes seems to be fine. I want to check if everybody can hear
Probably
you.
my voice. I've got a bit of a cold,
Okay,
and I do
okay.
apologize.
No, it
I'll
looks
bring
like
this closer.
No, it looks like they do hear you. It's okay.
Okay.
Thank you.
And I think it's when I turn my head to you.
It might be useful, just in relation to the responses, to take you to what comes later actually as an annexure, but it's a sort of summary page, as I have it, of the analysis that was done of the responses. You'll find that at page 256, which is under tab 13.
256.
If we could just take a look at this page, can you talk us through what is reflected there in relation to the entities as well as what is being evaluated?
So as we look at the summary, the first 2 pages prior to that, which is annexure A, B, and then into C, C summarizes everything that we have. So we had to look at the critical criteria at the time, and then the tenure and the funding instrument and the currency. So on the left-hand side is the detail of the loan. Moving to your right, from left to right, is a list of each of the clients that responded. So there was Seacrest Investments, who came up with the top. They came with an interest rate of 5.8%, and they offered a full amount of 15 billion. The calculated interest we did then, based on the loan, because their loan is fixed, at 740 million cost for SA. The next was Confetti, Innovex, Hammerschlag, Stanchart, ABSA, and Nedbank. If you look at Confetti, they offered a big amount of 2.1 billion, but their base rate was 6.5%, meaning that the interest would be 1.7 billion. It wasn't at the best interest of SA to go in for a higher paying interest loan. Innovex offered only 1.62 billion at a rate of 2.5%, whereas Hammerschlag also went in 15 billion at a 6.5%, and they had other terms like arrangement fees, upfront fees of 5.25%. So that was a fee we had to pay for them for advisory. So that would have also been expensive. And then Stanchart offered the 1.5 and ABSA offered 1.3. There, the 6.5 is the JIBAR rate at the time, which is the Johannesburg Interbank offered rate, accepted rate through all the banks. And then they put on a margin of 2.35, ABSA put of 2.5. Nedbank offered 1.5 at 6.5, same JIBAR rate. And theirs was shorter term.
We'll get to this point in due course and possibly, Chair, with your leave after the break.
Yes, we'll take the tea adjournment. We'll resume at 11:30. We adjourn. You may proceed, Ms. Hofmeyer.
Thank you, Chair. Ms. Stimpel, before the break, we were looking at the analysis table at page 256, where you were taking us through the analysis that was done of the various entities which had responded to the RFP. The point I was wanting to pick up on just before the break was you've got 3 banks reflected there in the last 3 columns, Standard Chartered, ABSA, and Nedbank. And the point you were making was that the amounts that they were willing to fund came in under the 15 billion. They were 1.5, 1.5, and 1.3, which, if my maths will do me justice, is 4.3 billion in total. Is that correct? Now, that was less, Ms. Stimpel, if you wouldn't mind just turning on your microphone so that your answer to that, the 4.3 was the total amount that the banks were willing to fund. Is that correct?
Correct.
We'll come to that in a moment, but that was less than the total that the RFP had indicated SAA was looking for. Is that correct?
That's correct. Our summation of it, that if we can't get the full 15 billion, we will then work with what we have, because we can always go out for another RFP or for the amounts we haven't covered.
Okay, so let's come to that analysis and the position that you then recommended should be adopted in relation to this RFP. Because you're highlighting both that Seacrest Investments, which is in the first column there, was indicating a willingness to fund for the full 15 billion, and as I look across there, had the best rate on that 15 billion as compared with the other responders. Is that correct?
Correct.
And then you spoke about an alternative in relation to the banks, who together were willing to fund 4.3 billion. Is that correct?
Correct.
So what was your recommendation after having assessed these various responses? What did you go to board with as a recommendation in relation to your assessment?
So our final recommendation, after assessing all the respondees' term sheets that we received, we recommended that Seacrest be chosen for 15 billion because they looked at the full consolidated amount and their interest rate was the better rate. However, while we were still doing our analysis, we did our own internal research on Seacrest, and we weren't comfortable that we couldn't get enough information, and so we asked our legal department to do a full due diligence on the client, which they did. The client...
Ms. Stimpel, sorry, if I may just stop you there, I'd like to take you to precisely where that's recorded in your recommendation. So let's go to page 226, if we may. That's under tab 12.
Got it?
This is a document from the group treasurer. That is you, is that correct?
Correct.
And it's to the Finance Risk Subcommittee, or FRSC for short. Is that correct?
Correct. This was the first one.
Correct. So this is your first recommendation, and that is to the Finance Risk Subcommittee. You made a point in your evidence a moment ago about wanting a due diligence to be done. I'd like to take you to page 234 to find that recorded. If you look at page 234, you'll see it begins with a heading E, conclusion.
Correct.
And what you are setting out there is at paragraph 25, the secured facility offered by Seacrest emerged as the preferred option for SAA, as it provides SAA with the following benefits, and then you list a number of those benefits. But at 26, you record there, before any bid is awarded, the necessary due diligence will be done on the preferred bidder. Is that what you were referring to?
Correct.
Right. And then if you go over the page to 235, you'll see your ultimate recommendations being recorded there, which I take to be consistent with what you've indicated already in your testimony. At paragraph 33, the recommendation reads that FRSC should mandate the acting chief financial officer as chairperson of the FRSC to recommend to the SAA Exco for approval of the secured term loan financing of 15 billion for a period of 10 years offered to SAA by Seacrest Investments, and then moving up the levels of at least authority to the SAA Audit Committee and then to the Board of Directors. So that, as I take it, was your first choice. Is that correct?
Correct.
And then tell us about 34. What does 34 cater for? Sorry, paragraph 34 on that page. We were looking at the recommendations, page 235.
235, sorry, I was went one page ahead.
So as I have it, paragraph 33.
I'm sorry, is that 335?
235, Chair, the page.
Yes.
And then we were first looking at paragraph 33, which captured your first choice, so to speak, in terms of the analysis of the funders. But then at 34, you catered for an alternative position, and I was asking you to explain that.
Correct. So because we knew that we still needed to do the due diligence at the time, and we put a contingency in that should Seacrest, for whatever reason, not be approved by board, we would then make a second recommendation. And we then recommended the combined of the other bankers and their total of roughly, it was 4.3 billion in what they had on offer in their term sheets at the time. So we made a second recommendation, but as a contingency. So it's, yeah.
And then you made reference to the due diligence that needed to be conducted. I'd like to take you to that, if we may. That you will find at page 274 under tab 14. What is this document?
So we had asked our legal department to compile a due diligence report on Seacrest, because when we received Seacrest's term sheet, we found that they weren't going to be the providers of the funding directly. They were using two other funders. One was called Mazi Capital, but on a very small percentage, and the massive part of this was primarily the big amount, 15 billion from GRISAG. And so we then asked for them to complete and compile a due diligence report, and based on that, we could then recommend them further.
I'd like to pick up a few points of that report. If you look at page 274, under the heading background, item 2, background, in the second paragraph under that heading, there's just a recount initially about how they were requested to do this due diligence. And then from the third sentence, it reads, "It appears from the report that Seacrest and its investors are reluctant to release the required information and documentation pending the outcome of the tender evaluation and announcement of the successful bidder. The requested information and documentation is critical in this type of transaction for SAA to make an informed decision on the contracting parties. Of more concern to SAA is the origin and availability of the funds." And then if you go over the page to 275, there is what I take to be the Legal Review Committee's recommendation in relation to that aspect. They recorded the first sentence there: "The due diligence process may be finalized post the award of the tender and during the contracting process and crafting of conditions precedent in the agreement." What do you understand that to mean?
That we would first look at any conditions that they need to comply with before we even enter into a contract. Should they fail passing that conditions precedent, then there would be no agreement and no transaction.
And it goes on, I think, correctly to reflect your understanding, because what I take the review committee to have done is to prepare a draft agreement for the proposed transaction with Seacrest, and with a copy of that attached. Now, Oddly, we have to go backwards in the papers to find that attached agreement, because it was in fact inserted after your previous analysis document. If you would go backward to 258 in the papers, that's under tab 13.
I have it.
So you'll see that is a page marked Seacrest Investments Loan Agreement, and it appears to be a draft of an agreement that would be entered into between Seacrest Investments and South African Airways, SOC Limited. I'd like to take you to page 263, because that is where the very conditions precedent that we were looking at in the summary of the legal review appear to have been incorporated in the draft of the agreement. Do you see clause 7 there is headed conditions precedent? So we're at page 263.
263, okay.
If you look at clause 7 on that page, it's headed conditions precedent. And then you see further down from 7.1 at 7.2 what appear to be a whole host of track-changed additional conditions precedent that have been added to the draft agreement. Let's just look at those, because recall, as we looked at the legal review, what they were concerned about, as we have it from their report, is that they couldn't get more information about the source of funds, what was, in a sense, standing behind Seacrest as the funder, and so their proposal was, during the negotiation process, you could secure SAA's position by adding as conditions precedent to the agreement these very aspects. As a legal matter, if they weren't fulfilled, the agreement would not come to operate. So let's go through some of them. They wanted at 7.2.2 a certified copy of the resolution of the board of directors of the lender. So they wanted some satisfaction, it appears, as to the board of directors approving the terms on which the transaction was to be fulfilled. At 7.4 over the page, 7.4 deals with the borrower. Let's rather go to 7.5. They wanted original copies of a report from an insurance advisor certifying that all required insurances would be in place. At 7.6, they wanted copies of all cover notes and statements issued in respect of insurances required to be in place. They wanted at 7.7 evidence that the bank account had been opened with the bank and that all applicable mandates were in place. They wanted at 7.9, oddly numbered because it comes out of order, the approval of the credit committees and boards of directors of each funder of the grant of the facilities to the borrower. At the next 7.8, they wanted such document and other evidence as is reasonably requested by the facility agent to carry out and be satisfied that it complied with all necessary know your customer and similar identification procedures under applicable laws and regulations under the FIC Act. What would that have to do with? Why would know your customer and similar identification be relevant?
Because you needed to know who you were dealing with. We did raise the concern that if we were getting 15 billion from a non-financial institution, and it was a client, we couldn't trace any further information just by Googling the general rudimentary type of research. We needed to know that this money was kosher money and above board, that it wasn't money that could be money laundering or coming through drug money or things like that.
So that is, as I understand it, what you regard 7.8 as being directed towards.
Correct.
Then at 7.9, there's even a condition related to the Reserve Bank, a certified copy of approvals from the Financial Surveillance Department of the South African Reserve Bank on terms acceptable to the borrower. Why would the Reserve Bank be relevant at all in this funding?
From a financial institution perspective, our Reserve Bank keeps a close I would say, control and oversight on the banks, and so therefore they are a stable company to get information from regarding your funders. And so because this client we didn't know, we recommended that we get something from the Reserve Bank. They should have been listed if they're going to be lending any huge amounts to borrowers.
Would the Reserve Bank also have been relevant if the funds were coming from outside South Africa?
That would be dollars. Then you apply, because there's the FICA Act, which complies internationally as well. And the Reserve Bank does play a role.
Thank you.
Correct.
And then at 7.10, they wanted certified copies of the latest audited consolidated financial statements of the investors and the latest audited consolidated financial statements of the funders. What I read behind that is that's what they weren't able to get out of Seacrest at the time that they were required to do the review. Is that a fair summary?
Yes, Chair. That's, yes, there was a list of issues that they were unable to comply with, and hence we were uncomfortable with the final due diligence. Correct.
So as I have your evidence, the recommendation initially that we looked at was to go for Seacrest first. The fallback position was the consolidation of the three banks' proposals. But that was coupled in the case of Seacrest with the need to do a due diligence. Is that correct?
Correct.
We then have the legal review report, which similarly, as we read it, raised concerns about the level of information they were able to obtain, but does record that their recommendation is that the due diligence process can be finalized post the award of the tender and during the contracting process by building in protections as conditions precedent. Is that as you understood it?
Yes.
And what then did you do in relation to the next round of approvals that you needed?
So after the next round was through the EXCO committee, which is our executive committee, and we put our normal submission through, listing again the Seacrest and our second choice being the banks combined. And we also had a copy of the due diligence report by then, which we had tabled at the EXCO and stated that we were not comfortable with the result of the due diligence at the time. At the EXCO meeting, it was decided to still put forward the recommendation through to board because we are covered in the due diligence that we will set the conditions precedent and that we will still minimize the risk for SAA should Seacrest not fulfill the final due diligence, and then that would be completely out, and we would then focus on the second recommendation with the combined banks.
Ms. Stimpel, as I read paragraph 43 of your statement, which is at page 8, you record there that you queried at that EXCO whether you shouldn't exclude Seacrest completely or still keep them in the recommendation and attach the due diligence report. Give us a sense of your misgivings at the time and why in the end, despite those misgivings, you went with the broad EXCO decision to recommend Seacrest.
Okay. Based on, thank you, Chair. Based on, firstly, me being old school, is that we've always worked, we had a history of working with banks, and we knew how the banks funded. There was always, right up front, we knew their legal team, our legal team, and we worked closely with National Treasury's legal team when it came to working the agreements. They understood the funding process, and with Seacrest coming up, it was great that they could fund SAA with a full 15 billion. However, my personal uncomfortableness arose from the fact that one was the due diligence wasn't really complete, and I still was not sure who Agrisac was and how could they be funding and where they were sourcing their funds from. And then thirdly, why I put it to EXCO at the time was, can we then just go with the banks and put a recommendation, was that they had said we've been tasked by board to bring in third parties. So let's go ahead with that. We're still protecting SAA at some degree, because once we've got the conditions precedent in, we have limited the risks that SA would face. So, but my personal view was, if I had to make the decision alone, yes, I would have not gone with Seacrest. Thank you.
You then recorded paragraph 44 that same recommendation that you made initially to the Financial Risk Committee is then placed before the board. Just to give you that reference, if you turn to page 244, which is under tab 13, you'll have your, as I have it, submission to the Board of Directors. Can you confirm if that's correct?
I have it. Yes, it is.
And as you say at paragraph 44, in essence, this is the same recommendation. Go with Seacrest first. If Seacrest fails, then go to the consolidation of the banks. Is that correct?
Correct.
And you'll find that, just for the record, at 251. And I see that reflected under paragraph 32. Is that correct?
Correct.
So you're now at, Ms. Stimpel, the 27th of November 2015. That's the date that appears on the first page of that submission that you did for the Board of Directors. Is that correct?
Correct.
And you've been through something of a process by this stage. You tried one RFP in February 2015. It had to be withdrawn. You then are instructed to do a further RFP. You go through that process. You get responses. You analyze them, and this culminates in this submission to the board on the 27th of November 2015, right? We now are going to move to what then happens and what decision the board took after this really year-long process by this stage. And for that purpose, we should turn to paragraph 45 on page 8 of your statement. If you go back to the statement, or the affidavit at least. Well, let's start with your expectations for this board meeting. What did you assume you would hear the following week after you sent this detailed submission to the board?
After the board meeting, my expectations would have been that board would have either have approved the Seacrest or turned Seacrest down and approved the consolidated banks. And if they didn't want that either, they would have then instructed us to go out on another RFP and see what else is out there, because that's what I would have expected.
Right. That is not what occurred, is it?
No.
So you detail in paragraph 45 what did occur, and can you tell the chair what then eventuated? Ms. Stimpel, if I may just ask you to come closer to the mic or bring it closer to you, just so that we get you adequately on record.
Okay.
Thank you.
What happened is that the board meeting did take place on the 3rd of December, Chair, and subsequent to that, I'd followed up, which is a normal thing we do. We follow up with Company Secretary's office to get the board resolutions. Once we get the board resolutions, we then implement whatever the resolution is. And on the Monday, when I came into the office, I followed up on whether we have a board resolution yet on the funding, and I was told, no, not yet.
And the Monday would have been what date, if you remember? The board meeting was on the 3rd of December.
I think it was the 7th of December.
Okay,
I'll
more or
just
less.
check that,
We
Chair.
can check it.
Okay.
Please continue. I'll give you that in a moment.
Thanks. And we, when we did get the board resolution, it was really unusual for me to see this, in that the board resolution was stated that our first recommendation to Seacrest was declined. The second recommendation for the consolidated banks was also declined. And then the third part, it makes a recommendation for us to go with funding for a company called FDC, which was Free State Development Corporation, and authority is given, or the mandate is given to the acting CEO and the interim CFO to go ahead and sign the deals and make sure that this loan happens. And then it mentions, because of a letter which was circulated at board, and that immediately I questioned, because I said, how can a letter that didn't go through the formal process of the RFP process and now come to board and a decision is made on that letter?
Ms. Stimpel, if we may, could we go to the letter just while
Please.
you're at it in your testimony? Let's go to page 287. That's under tab 15.
I have it.
Ms. Stimpel, it's often necessary with witnesses, so I'll be doing this a lot in the next few weeks, to clarify what you had knowledge of at the time and what you have subsequently gained knowledge of. At the time of this board decision on the 3rd of December, had you seen this letter?
No. The first time I saw this letter was through the Zonda investigators when I was called in to give my testimony, and then with them and myself working together to put through evidence, they showed me this letter. So that was the first time I got to know about this letter.
Okay, let's
Thanks, Chair.
focus on it, if we may, for a moment. This is a letter dated the 2nd of December 2015 from the Free State Development Corporation to South African Airways, authored by Mr. Moyo. And it records that the Free State Development Corporation is a Schedule 3D company in terms of the PFMA. The corporation offers financial and non-financial support in terms of the FDC Act. And it goes on, subsequent to our discussion, this is addressed, you'll see your reference at the top right-hand corner, records P. Nancy as the reference. That is a reference to the interim CFO at the time, Ms. Nancy, who will be giving evidence before the Commission next week. It says, subsequent to our discussion regarding funding that we provide, we are in the process of exploring a joint venture between FDC and a foreign investor through its newly formed subsidiary in the Free State. And it records that the investor has indicated that there's an appetite for government-owned entities such as SAA who require funding. This is a first of its kind within FDC, but we would like to explore this opportunity and provide such funding to yourselves. This is subject to investor agreements reached and also PFMA approvals sought. I will keep you informed if this materializes, and we will negotiate terms at that point in time. The funder has indicated that it is low-cost funding, but this matter is under discussion. I envisage this to be between 3% and 6%. Please note that as we discuss, this letter is not a commitment, but one of the solutions we may explore in future together. I look forward to engaging you further as we progress on this matter. Ms. Stimpel, your comments on that letter, would this have been enough, if you were sitting on the board, to motivate you to decline the recommendations that had come through a process and give a decision to sign an agreement with FDC?
No, I would not have, because I think board should be clued up enough to know what the mandate of Free State is, firstly, and then if one looked at the rate, it was 3 to 6%. They were only, this was an exploratory letter, the way I see it, and not a firm commitment. And they even state this is not a commitment. So for board to have made that decision and put it into a board resolution showed immediately that they had, they obviously wanted FDC in without going through the proper governance process. So no, I would not have done it. Thanks.
We'll look at that board resolution in a moment, but you made a point about the board knowing the mandate of the FDC. And I'd like to pick that up because that mandate is clearly indicated, Chair, in the governing statute that creates the FDC. We've included it in C, Bundle C of Ms. Stimpel's evidence, and you'll find it there at page 904. It is under the tab A2.
Yes, I've got it.
And Ms. Stimpel, if you go over the page to 905, you'll see Section 3 of that Act talks about the main objects of the corporation. I'm going to come back to Section 3. I'd like to start over the page at Section 4 because Section 4 defines the capacity and powers of the corporation, and what's relevant is that it defines that capacity and powers with reference to the main objects stated in Section 3. You'll see there that Section 4 reads, the corporation shall have the capacity determined by the main objects. So when we want to work out what legal capacity the FDC has to engage in activities, whether funding or otherwise, we must look to its main objects under Section 3. And if we go to Section 3, you will see that its objects, and we'll go through them, do not appear to include...
Mayor,
yes.
it's quite strange that Section 4 says the capacity is determined by the main objects, because objects and capacity are different things.
Indeed.
You must have capacity in order to do
the
something to achieve the objects.
Indeed.
So how do you look at the objects to determine capacity?
Chair, as I read it, what Section 4 is seeking to signal is that that capacity which the corporation has is within the limits of the objects it is required to pursue within Section 3. So in other words, no capacity beyond what those objects identify as that which the corporation must engage in. It seems to me the only way sensibly to read the two, but I agree it is unusual to define capacity with reference to objects.
Yeah, particularly if one is thinking of legal capacity.
Yes. It does seem to signify legal capacity, whereas objects are usually aims objectives of an entity.
Yeah.
Certainly
Anyway.
the approach that was subsequently taken by National Treasury and others was that the objects of the corporation did not extend to the type of funding that FDC was to engage in. And Chair, the reason for that is if we look at 3A to F, you will see a keen emphasis on activities within the Free State. This is, of course, the Free State Development Corporation, and it also has an emphasis on development of small, medium, and micro enterprises, neither of which are SAA. A is under Section 3A, promotion and development of SMEs. B is to assist the Free State-based small, medium, and micro enterprises with funding. C is to assist Free State-based small, medium, and micro enterprises in financial distress. D is to initiate economic empowerment projects that would benefit the Free State. E refers to promoting investment and trade in the province. And F talks about undertaking, at the request of the responsible minister, activities which, in summary, will contribute to strengthening of the provincial economy. So those objects give a clear reference point to activities within the province, small and micro enterprises there, and in a sense, acting with funding and financial assistance within the province.
Effectively, it may be that in order to give meaning to Section 4, one must read Section 3 as powers rather than objects.
Indeed.
Powers of the corporation, what it may or may not do.
Chair, it seems to me to be the only sensible way
Yes,
to read them
yes.
together. In essence, when it says the objects of the corporation, it could as easily have said the capacity or the powers
Or
of the
the
corporation.
functions of the
Indeed,
powers, yeah.
could be.
Yeah,
Indeed.
okay.
Chair, that is, we will hear in Ms. Stimpel's testimony in due course, what appears to have been the attitude taken by National Treasury on the question. But Ms. Stimpel, for now, you raised the concern, well, who is the FDC and what is their mandate? And as I understand your testimony, had you been sitting on the board, that would have been one of the questions that you asked. Is that correct?
Correct.
Well, let's look at the board decision itself, because I'd like to take you through some aspects of it. It is relevant will be relevant in due course, Chair, also to the evidence of Ms. Nancy, because she deals with this also in some detail. You'll find that resolution, well, at least an excerpt from the draft minutes which record the decision of the board, in the A file, which we were working with previously, under tab 16 at page 289. Chair, just for the purposes of the record, we have confirmed that Monday that Ms. Stimpel referred to was the 7th of December.
Oh, thank you.
So if we can look at that excerpt, is this something that you saw at the time? Were you provided with this?
The board resolution, I had to ask for it.
But you did see it back in December
Yes, I did.
2015. Unlike the letter, which I understand your testimony to be, you were showed in the course of your engagements with the Commission's investigators. Is that correct?
That's correct, Chair. I only saw the board resolution. I did not get to see the FTC letter.
Did you ask for the FTC letter at the time?
I did. I did ask because I wanted to see what was stated in it, and I was told that it was part of board and I didn't need to see it.
Okay, so let's look at the resolution because there are three parts to it. It starts with the board's reason for declining the Seacrest offer, which is the one that you and your team had recommended first. And as I read it there, they say under A, the Board of Directors resolved to decline the secured term loan facility of 15 billion for a period of 10 years offered to SAA by Seacrest Investment for the consolidation of the current debt portfolio of the company. And now comes the reason, due to the lack of information in the due diligence report and the reluctance by Seacrest to provide proof as to the source and availability of funds. What is your take on that decision, Ms. Stimpel? Would you support it? Would you disagree with it?
I would have supported it with the information of the due diligence report, yes indeed, and also reluctance of Seacrest to give us proof of where the funds were coming from. So yes, I would have supported that.
Would the conditions precedent in the agreement not have been enough to satisfy you that SAA was protected, or would you still have been cautious?
I would have still been cautious, and with board giving the final directive on this, then tells me okay, but I would have been far more cautious, especially since they're a non-banker.
Okay, and then let's go to B, because B deals with your alternative, right? And what I think you described earlier as the old school approach to this analysis of your responses. What did they decide at B?
So in B, we made a recommendation for the consolidated of the banks, Chair, but this was also declined. Based on that, the funds offered would be not sufficient to consolidate the debt. So the total debt would have been like 4.3 that the consolidated banks would have been able to provide, and it meant us going out again for another RFP. I didn't have an issue with that. I felt that this one could have been recommended because we knew the banks, we knew how they work, they had an efficient legal team, and we knew that the funds once that agreement is signed today, tomorrow the funds are in our account. We do not have to wait lengthy days, etc. And so it was crucial for SAA's cash management that we needed to have those funds at the time as well. So the fact that they declined it, that it wasn't sufficient, for me wasn't, I was very uncomfortable because I felt that we could have gone in another RFP. We take what we can get now, and then we just put out for the balance that we don't have. Thank you.
Did you attend that meeting on the 3rd of December?
No, normally I do attend the board meetings. Especially when it comes to either the funding or hedge proposals, if we're doing any hedging. And when Mr. Wolf-Meyer was there, or the previous CFO, Kaushik Patel, or whoever, I attended and presented at board meetings. This particular board meeting was one of the first that Ms. Nahansi was attending, and she gave me directive not to attend this meeting. She said, be at your desk and be on standby. If I need you, I will call you. And that's what I did. I stayed at my desk waiting for her call. I did not attend that meeting because I was not called to that meeting.
Were you called on at any point to attend?
No, Chair, I was not called at all to attend the meeting that day or any subsequent days.
And this explanation that you've given now about, in a sense, banking the 4.3 billion because it would alleviate the immediate pressing difficulties of SAA, and then going out on another RFP. Do you have any knowledge as to whether that was put to the board in the course of its discussions?
I wasn't present, and also I don't have access to the minutes of the board meeting at that time, Chair, so I wouldn't know if that was discussed at all.
I intend to go to the board minutes in due course because we have managed to source them, Chair. But for present purposes, we can certainly state that the minutes don't reflect any of that sort of discussion. Chair, that doesn't mean it didn't take place. The minutes are sometimes an abridged version, of course. But had you been there, let's put it that way, Ms. Stimpel, had you been there, when you learned that the board was intending to decline your second alternative, would you have made these points to the board?
Chair, I would have. I'm quite forthright in stating certain things, and especially if it's at the best interest of the organization. So I would have stated that, yes.
And then let's move to C, because C captures the board's decision in relation to the FDC proposal. It's fairly important, in my view, to look at this language particularly because there's some debate as to what the board actually decided at this meeting. But let's look at it. C records that the board approved that the interim CFO and acting CEO urgently take the necessary steps to negotiate, conclude, execute and sign and or dispatch all documents and notices related to the 14 billion loan offer received from a potential funder, Free State Development Corporation, SOC Limited, FDC, as per the letter circulated at the board meeting. So let's stop there. What do you understand that to be saying?
How I understood it from day one, having read this board resolution, that board is giving approval to the acting CFO and the CEO and CFO at the time to go ahead with a 14 billion loan with a client that did not come through the normal RFP process and based on a letter that was circulated at board. For me, hence the reason I asked to see the letter. I thought it was a term sheet that was put forward, and therefore board could do comparisons, because in our document they would have already attached in our annexures was the final outcome. That analysis we went through earlier was attached in their annexures, so they could have done comparison, and maybe that's the reason they made the decision. But I was not privy to see that letter, and hence my only conclusion was that this was not done according to our due process, our corporate governance process, and I was extremely uncomfortable with it.
Ms. Stimpel, let's look at the reason given, which is the last sentence of that paragraph C, for the board selecting Free State Development Corporation, because I'd like to have your comment on the reason that was given from the board. Of course, had you been at the meeting, you might have been able to give it then, but that was not to be. Let's look at paragraph C, the last sentence. The board recognized that as a state-owned entity, the FDC carried less risk for the airline, and in the unlikely event of default by SAA, another SOC would treat SAA differently than a private lender. Ms. Stimpel, as I read that, there are two statements being conveyed there. I'd like to focus on the first. The first, as I read it, is that the board recognized that the FDC carried less risk for the airline. What would be your comment on that? Would you have agreed with that determination by the board?
Chair, no, I would not have agreed with that, because one is looking at also similar basket of risk. So you've got FDC, who is part of government. You've got SAA, which is a state-owned company. For them to be lending SAA, we're concentrating the risk within government. So I do not see it as a lesser risk at all.
And then they went on, as I read this, to give their second reason, which is their sense that in the unlikely event of default by SAA, another SOC would treat SAA differently than a private lender. What would be your comment on that rationale?
I think when one goes into funding or any, you build a relationship, Chair. And so with, I can't see that FDC would have treated SA any differently. What I do see is that the impact, the knock-on effect of the whole funding, say SA does default, it will immediately maybe cripple FDC. Who knows what would happen? So what's the impact on the overall funding of government, or the overall impact of all the loans that that South Africa has? So I disagree with that completely, that comment.
And they say in paragraph C that they approve that the acting CEO and the interim CFO urgently take the necessary steps to negotiate, conclude, execute, and sign, and or dispatch all documents and notices related to the 14 billion rand loan offer received from the Free State Development Corporation. Was there another document other than the one we have looked at, which had come from the Free State Corporation? We looked at the one, I think, at 278, which said, among other things, this is not a commitment. Was there another document that had come from that corporation other than that one?
Thank you, Chair. At the time, there was none besides this letter. There could have been other communication between Mr. Moyo and Ms. Nahansi that I'm not aware of, but no other sort of commitment about the transaction of 14 billion that I know of. What we did is that I took this document back to our Financial Risk Subcommittee, circulated it to them, and I listed my reservations on it and said, and made recommendations saying that we need to send the RFP out to FDC. They need to complete it like every other respondee has done. Once they've completed it, we'll do a full comparison, and once the comparison is done, we're able to do that. Based on that, our FRSC agreed, and that's how we sent the RFP out. I recall even having an argument with my deputy at the time, who felt that we should just follow this board resolution to the letter. And I said, no, this is inaccurate. I'm not prepared to follow it the way it is. And hence, we will rather let the RFP go out to FTC. So we did. On that agreement, We sent it out to them sometime in December, and they responded by the 24th of December. And yes, we do have a full term sheet from FTC. Thanks, Chair.
So when in paragraph C at page 289, the minutes say that refer to a loan, a 14 billion rand loan offer received as per a letter that was circulated at the board meeting. Is that a reference to the letter at page 287, which says this is not a commitment?
Yes,
That is
Chair.
it's a reference to that letter.
correct, Chair.
But isn't that strange, because I don't see any reference to 14 billion rand in that letter. Do you see it?
There's no amount stated. There's no
Yeah.
tenure stated.
Yeah.
There is a range of 3 to 6% only, and just the openness that we're willing to fund.
Do you know where the board was taking the amount of 14 billion rand from, to which they referred in their minutes?
We had put through, the initial amount we had put through, Chair, was 15 billion. For board to write the 14 billion, I felt it was probably a typing error, because they just put 14 billion. When we went out and sent the RFP out to FTC, we sent it out on a 15 billion.
But the Free State Development Corporation had never, as far as you know, in writing, offered a 14 billion rand amount loan.
Not that I'm aware of, Chair.
Yes.
No.
But also, the minutes talk about there having been an offer. So this letter being an offer, is it an offer? Was it an offer from the Free State Corporation, as you understand it?
Chair, that's not how I understand it. It was definitely not an offer. It wasn't a firm commitment, and they didn't come and say, we can offer you this amount for this rate, fixed at this cost. Even they have a line there saying it's not a firm commitment.
So, but how is it possible that a whole board could make a resolution that talks about a 14 billion rand offer on the basis of a letter, one that doesn't refer to such an amount, two that clearly says this is not a commitment? Is that something you are able to explain, or you are also not able to understand?
Sir, I can only...
Or maybe you have insight as to how they could have
Yes, Chair,
talked
I
like
can
that.
perhaps look at the constitution of the board at the time, and that would give you an indication of how decisions were made. So the constitution consisted of chairperson being Ms. Dudu Myeni, Ms. Kinana, Yake Kinana, and Dr. Tambi, and then Ms. Nahansi and Mr. Twane.
Chair,
And yes.
apologies.
Yes, and I see they already say the interim CFO and the acting CEO must go ahead and do everything and sign and execute
Correct.
without seeing any further information that they would have needed to see to have a commitment of this nature with any entity.
Exactly, Chair, and that is what concerned me, because there was no letter forthcoming. I asked for a term sheet. There was no term sheet forthcoming. I was even asked to ratify this board resolution, and I said, no, I'm not doing anything until I get the full, well, not the board resolution, to ratify the decision of FTC. And once I received the board resolution and saw that the decision was made via a letter, which I wasn't able to see, I was very uncomfortable, and I stated that. And hence, with the FRSC, we said we will follow due process rather. We will rather send out another RFP, because our recommendation was scrap everything and start again. Or send out a RFP to FTC, then do your comparisons. And they said to save time, let's just send the RFP out, which we did. And only based on that, once we received the RFP back from FTC, were we able to then assess where they could fit in with the comparisons of the other respondees.
Thank you.
Thanks, Chair.
Thank you. Ms. Stimpel, you recorded that and your reservations about it in an email on the 9th of December. You made reference to it a moment ago. It's at page 291. That appears to be, we now know, the Wednesday of the week, because the 7th of December was the Monday. And as I read that email, you're recording some of the very reservations that you recount to us now about how this could possibly work in a way that would follow process. Is that a fair summary of your concern?
Yes, Chair.
And if we go back to your affidavit at page 9, paragraph 49, that is where you recount what you've just indicated in your testimony about the instruction from Ms. Hansi that you ratify that the FDC be appointed, and you record there that you refused, and you told her that you were not willing to take any instruction without receiving the board resolution. I assume that's because that conversation happened prior to you actually seeing the board resolution. Is that right?
That's correct, Chair.
And then, as I have it just in time, you got the board resolution and then you write this email, because now you've got the board resolution. It's telling you to go and appoint on the basis of a letter, and your email sets out your concerns about how you could possibly do this in a regular process. Is that correct?
Correct. Yeah, I even state there that we need to reopen the RFP tender and then add FTC and send it out to them.
Well, what did happen in terms of procedure? What did you do after receiving the board resolution?
So once we received the board resolution, Chair, we then did send the RFP out. In fact, it took us a couple of days to get the contact details of Mr. Moyo, because none of us of my team were in contact with Mr. Moyo from FTC, and we had written emails and called Ms. Nahansi, who eventually gave us the email address. And my colleague, Michael Klein, then sent the RFP to Mr. Moyo and gave him 2 weeks to respond. And he did respond by the 24th of December. And thereafter, we did our analysis. Thanks.
Ms. Stimpel, if you go to page 10 of your affidavit, you'll see at paragraph 53, you say there was a concern that we were already acting outside proper procurement governance processes because of the board involvement and the fact that the deadline, I assume that's a reference to the deadline on the RFP, had long passed. You say, I asked Ms. Nancy if I could see the FDC document. She told me that I could not, as it was circulated at board meeting and there was no need for me to see it. I therefore had no idea what was contained in the process. I had no name, no contact number, no email. I had no evidence that FDC had even made representations. I'd just like to ask you to pause at that first sentence. And Chair, this is another aspect that comes up in the contrary versions in the cross-examination application. So I'd like to put it to Ms. Stimpel for her response. Ms. Stimpel, you are criticized for, on the one hand, earlier on in your affidavit, making the point that funding was an aspect governed by the funding policy of SAA at the time and not supply chain management policies. But then later in your affidavit, and I would suggest that this is an example, saying that you were concerned about proper procurement process being followed. What is your response to that criticism?
So, from a funding perspective, historically, SAA has always gone through the Treasury Department for funding and our own set of governance approvals and committees. My concern here was one that board has actually dictated that they wanted to be involved in the RFP, that it needed to be approved. Then they dictated that they wanted to add some entities to it. And then the third thing was for them now to actually add a new client when we've already completed an RFP process, and bring a client in right at the end and say, go ahead with this client. So those are my concerns, that we weren't following the proper governance process.
Thank you. At paragraph 54, you talk about the financial position of SAA as you approach the end of 2015. And that does become relevant later in terms of questions of urgency in procuring this funding. Can you tell us what that financial position was in December 2015?
So at that time, we had government guarantees with National Treasury of roughly about 14 billion, Chair. And SAA had borrowed roughly about 11 billion. So we still had 3 billion unutilized guarantees. So it meant we could still use it. SA was going through a process where they were, to meet all their obligations, they were going into a tight cash crunch, and therefore needed to ensure we could borrow money. The current and existing loans that they had at the time, towards the end of 2015, were all coming up for maturity. As we read in the previous, there was one for November, then and earlier and later, earlier in the new year. So those were coming up for maturity. But once you've borrowed the funds and you're only rolling over debt, it's not new money coming in to your bank account. And so the 3 billion is what we still had, which we could borrow and use. And hence, if one looked at the new proposals put by the consolidated debt, part would have been rolled over, and the other part would have been new debt to add to it. So we would have had new money coming in into SA's bank account. With the board holding back, and for us to go out again on the RFP and with the FTC, meant we delayed the process of borrowing, and we now had to go through the process again. But with SA being in a crisis situation of needing cash to meet its obligations, we made the recommendation, and this also had to go to board. So the same process we put to board, and we explained we need the money now. So now we would like a bridging finance, while on the side the long-term finance is happening. We will go short-term finance, a bridging finance for 3 months, and we went the first in December for 1 billion, and in I think end of January we borrowed another billion, and end of March we borrowed another billion. So that's how we used the 3 billion during that time.
And from whom were those funds borrowed?
The banks, sorry, they were from the banks. So it was Standard Chartered, gave the first 2 billion, and Citibank gave the last.
I've just noticed it now, Ms. Stimpel, but I assume at 54, Citibank there is spelt incorrectly. It should be with an I, is that correct?
Correct, not
Thank
a
you.
Y.
It's not a new banking entity of which we were not previously aware. We'll make that change at page 10. Ms. Stimpel, you then go on at the bottom of page 10 to talk about the process. You've already indicated in your testimony that your colleague, Mr. Michael Klein, sent out an invitation now. Once you'd been able to secure the FDC details, as I have it, he sends out a proposal, well, a request for a response to the proposal to FDC. Is that correct?
Correct.
And then at 56, you talk about a concern that was raised from the legal department of SAA. Can you tell us about that?
Yes, because we have a cross-functional sourcing team, especially with the funding, we have our legal person was Ephraim Lusenga, and everything we've done regarding funding, he's copied on and very closely involved. And he raised the question when the FTC issue came up, whether a legal due diligence was done, and can it be conducted on it. He had written in the email, which we had all circulated, and Ms. Nahanti had said that it will be conducted. And confirmed that.
Ms. Stimpel, isn't that the wrong way round, though? It seems to me odd, and I'd like your comment on this, that the board decides to approve a funding offer, but we don't seem to have evidence of the offer in the letter, which is the only letter we're aware of having been circulated to the board, decides that they must empower people to conclude that transaction, but then a week or so later, the due diligence is going to be done. Is that unusual?
That is very unusual, because everything that goes to board, you should have done all the groundwork. So you would have had your due diligence done, because you're making a recommendation, a final recommendation, and that should have been done already and then presented to board so that they can make an informed decision.
Those minutes of that board meeting, I didn't understand them to even be to the effect that the interim CFO and the acting CEO should conclude an agreement if certain conditions are met, like if due diligence, revealed that everything was okay. Is that your understanding as well, that that authority given to the interim CFO and to the acting CEO was not subject to any requirements or conditions being met?
Yes, Chair, I agree. There was nothing written in the board resolution of that. It
And
was
that
just
must
giving
have
them
been, yes.
complete authority to go ahead and transact the
And
deal.
that must have been quite risky and dangerous for the board to authorize something like that in circumstances where it was not saying the homework must be done first to satisfy SAA that everything would be in order if it had a commitment with the Free State Corporation.
Your summation's correct, Chair.
Yes.
Exactly.
Ms. Stimpel, you referenced the fact that when Mr. Lusenga raised this concern, and just for record purposes, you'll find his email at page 303. That is under tab 20. You'll see in the middle of that page, there's an email from Mr. Lusenga to Mr. Klein, Ms. Nhansi, and you are amongst the copied recipients, in which he says, "Dear Michael, are we going to conduct a legal and financial due diligence on FDC?" And then the response from Ms. Nhansi is above that. She says, "Good day, yes, we will perform the legal due diligence, and I'd like to suggest we give that mandate to Ursula at legal department." She says, "We had an EXCO meeting today and that they suggested that we extend the scope of this and not only send the RFP to FDC, but also send it to IDC and PIC as well, so that we can see whether we can get better rates. I saw that you have already sent the RFP to FDC, and thank you for thanking. Could you please send it to PIC and IDC as well?" Again, back to the Chair's earlier point, this all seems fairly curious, because you've got a board decision on the 3rd of December that is saying do the necessary to conclude this. Then you have people like yourself raising concerns about process, Mr. Lusenga. It appears as though some of that was taken on board because there's now going to be some process. But what was your response to the suggestion that the IDC and the PIC be included as well in this further net of potential funders?
We had already sent, they were one of the ones we included in the earlier ones, and they didn't respond. Right from the start, when I first started at SAA, we also tried to see if DBSA would fund SAA. This was in the early years, probably 2008. But we knew that their mandate was not to fund state-owned companies, and so therefore we never considered them in the later years, because we knew they couldn't. So when this suggestion was made to go to the PIC or to the IDC, we didn't even act on it because, again, it is in an email. There's no board resolution for that, and so we didn't act on that.
And then over the page in your affidavit at page 11, you record the response that was received from FDC. That was received on the 24th of December 2015. And if you go to page 313, which is under tab 21, you'll find the FDC proposal that was submitted in response to Mr. Klein's email earlier in the month. And if I could take you to page 316 of that annexure. What is that document?
So the 316 referral is the term sheet we received from FTC after we had sent our RFP out. And if one looked at the RFP, this was the, we sat as a team going through this, and there you can see who's the borrower, which is SAA, the lender being, and here they state a joint venture between Free State Development and GRISAC. And immediately I realized that we've already come across GRISAC as a joint venture partner with Seacrest in the previous. And the board had already turned that down, so why would board now agree to something that they've previously turned down? Because we couldn't meet, they couldn't meet the due diligence with GRISAC. Do you need me to go further?
I'd just like to look at, first of all, the interest rate that is charged there on this funding. You'll find that at 318. What is that rate?
The interest rate quoted by FTC to SAA at the time was 4%. It was a fixed interest rate.
Ms. Stimpel, there's an aspect in relation to these rates that I need to traverse with you, because it's again an aspect that will come up in the evidence of Ms. Nhansi and is an aspect of the application to cross-examine you. As I understand Ms. Nhansi's point on this, and she'll certainly correct me in due course if I'm wrong, she criticizes you for having supported the Seacrest initial funding proposal, because you'll recall that their rate was 5.8%, right? And she says, well, they were also to be funded they were the intermediary for funding that was going to come from GRISAC, and GRISAC's rate was 4%. So she says when you approved the Seacrest or recommended the Seacrest proposal be accepted, you were satisfied that Seacrest, as the middleman, so to speak, would earn the difference between 5.8% and 4%, which would be a 1.8% fee, effectively, to Seacrest as the middle person. Chair, all of this is going to become very relevant later, because precisely what percentage the middleman, for want of a better description, gets becomes pertinent when this funding develops in due course. But the point being made by Ms. Nhansi, as I understand it, is you took issue later with a 1.5% being the fee for the middleman in circumstances where you were recommending Seacrest, who is going to earn a 1.8% as the middleman. What is your response to that?
Chair, we work with the term sheets as we receive it. So Seacrest had sent a similar term sheet like this, and the interest rate they quoted was 5.8%. And it was a fixed rate. There was no additional margin. There was no lead arranger fee. There was no other type of, there may have been default fees, all the smaller type, but nothing. So when we did our first analysis is what we've received based on the term sheet, which is 5.8%. Had GRISAC, and what I'm hearing is that GRISAC had also offered 4% to Seacrest. We were totally unaware of it. So I wouldn't have been aware of it, neither would any of my team or the rest of the cross-functional sourcing team have been aware of it, because it's not stated in the term sheet, and that's what we work on. Thank you.
And if I may just remind you, we don't have to go back there, but in that analysis table that you did originally of the rates from Seacrest amongst others, if you look across at the rate, as I see that page, 5.8% is the best rate on
Was
that.
the better rate out of each of the other banks that responded, or entities which responded. Thanks.
Right. But now you do see a term sheet provided by the FDC on the 24th of December, identifying GRISAG as its JV partner, in which the interest rate is a fixed interest rate at 4%. Is that correct?
Correct.
Is that the first time at which you knew of the GRISAG rate being 4%?
Yes, Chair, that was the first time.
Thank you. We then move at page 11 of your affidavit to what National Treasury was making of all of this at the time. Can you tell us what the nature of your engagements were with them and what attitude they had taken to this FDC being a potential funder to SAA?
Well, throughout the 15 billion process, National Treasury was part, they wanted to be kept part of the process, and when the FTC resolution came up, I had notified National Treasury about it, and we advised them that we will be sending out an RFP and we'll do our final analysis on it. Once we received the FTC, we had a meeting, and we also called in 2 representatives from National Treasury, who then sat with us, because they said they're only observers, they're not part of the decision-making process. It was with us. We went through it, obviously, and again, we looked at what benefit would it be from an interest rate cost-saving perspective for SA, and if one looked at a 4%, it was indeed far better than 5.8%, which Seacrest was offering. Our concern was that we're using the same party. There was GRISAG. We struggled getting a due diligence, and now we've got GRISAG again. We had debated that in our meeting, and we then gave over to National Treasury to speak. Their focus was straight away and said, FTC is not mandated to fund state-owned enterprises. They are mandated to fund projects and other organizations, development organizations specifically, within the Free State only. Thank you, Chair.
And as I have it over the page at 12 of your affidavit, that occurred at a meeting on the 6th of January 2016. Is that correct?
Correct, Chair.
And what did you then do with that information from a National Treasury in relation to feeding it back to the then CFO?
We then set up a meeting with the interim CFO and gave her the feedback of our analysis. We had to show her that, yes, FTC does come out tops because they're now showing 4%, but we have we had National Treasury at the meeting. We advised that FTC does not have the mandate to fund us. We took that and presented it to the interim CFO, Ms. Nahansi, and she told both Michael and I to leave the meeting, leave the matter with her, and she will be meeting with Mr. Moyo, and she will get back to us.
Did she get back to you subsequently about FTC?
Not until the 20th of April. We kept asking what's happening with the matter because we had not closed the RFP. Normally when you close the RFP is when you go back to all your respondees and tell them you've now chosen this as your service provider or your final bidder, and you send out letters of decline to the others. We have not done that. We had asked Ms. Nahansi, must we do that? And she said, hold on until we can fine resolution with FTC, or she was meeting on her own, and then we will finalize it. So we hadn't closed the matter with any of our respondees. And secondly is that we kept asking because we needed to close this matter, and only when I insisted on a meeting on the 20th of April did she say then that the FTC matter was off the table. Thanks.
Thank you, Ms. Stimpel. We'll come to that meeting in due course. But between January and April, there are quite a number of developments around the appointment of a transaction advisor that I'd like to take you through. If we can go there at page 12 of your affidavit. At paragraph 64 on that page, you begin with what Ms. Nhansi said at the end of that meeting on the 6th of January. As I have your testimony, you met with her after your meeting with Treasury. You conveyed to her that National Treasury's view was that the FTC did not have the mandate to fund SAA. And then what did she tell you at the end of that meeting?
At the end of the meeting, as Michael and I were about to leave the meeting, Michael Klein, Ms. Nhansi told us that the board has given approval that we should get a transaction advisor. And I questioned that and asked, why do we need a transaction advisor and what would they be doing? And she said, we need them to look at our debt portfolio and to look at restructuring the balance sheet, etc. And I still stated to her, but that's what we've done. We do that in Treasury. The restructuring of the balance sheet is done through our finance department. That is all done. Recommendations are made constantly. Thank you.
Ms. Stimpel, you may not be aware of this, but there has been quite extensive evidence already before this commission about the role of transaction advisors. Chair, it's a point that in the evidence you've continued to raise with respect. People within SOEs who are drawing salaries, who are doing this work, and then circumstances where people from outside are asked to come in and do that very same work. Was that your principal concern?
Yes, that was, because we've already presented it, and we, in every report, all our concerns, all the debt portfolio, the maturity profile, the high interest rates are reflected in those reports already.
Ms. Stimpel, if I may, and I'd like your comment on this, as I see it, it was more than that you'd reported on it. Those reports had actually been adopted by the board in the previous year. Is that correct?
That's correct, Chair.
Ms. Stimpel, Ms. Nhansi takes issue with this point, that there was no need for the transaction advisor. And in her statement, she deals with 3 reasons that were given by the board. I'd like to take you through those. The first of those is the, as she has it, first reason given by the board for this transaction advisor being required, and that is that there was no skill or expertise at Treasury because your predecessor had left in 2015 and you had only been in the position for 8 months. What is your response to that?
I think that is incorrect, because I've had the experience. I've been there for 10 years. And secondly is I've always deputized, and I've been presenting at board meetings regarding key focus areas regarding Treasury, SA's finance, SA's hedging portfolio, the policies. That same financial risk management policy was one of my key objectives that I had to achieve every year, review it, do a benchmark across the country and internationally. So, and all those facets of funding is in that policy. So I think that's an incorrect statement.
The second reason that she recounts having been given by the board for this decision that a transaction advisor should be appointed was that the amount, I take that to be a reference to the 15 billion that was being secured as funding for SAA, was within the board's delegation of authority, and they needed assurance from an external independent source. what would be your comment on that reason?
You know, at the time, I was also, again, very uncomfortable. I just felt we were in such dire straits to save every cent. And here we were going to waste money continuously on getting different opinions from others. And so for this particular one that they're saying it's within the board's approval DOA, for me, I felt that every submission we made to board, it means they're either not interrogating it properly, reading it, and seeing that we are raising the red flags around it. So yes, the statement also was inaccurate.
And then the third reason that was given was that Ms. Nhansi was new, and so she didn't have the requisite institutional knowledge. Do you think that should have justified the procuring of a transaction advisor?
No, I think Ms. Nhansi could have relied on her team. So she had us in Treasury, who she could have relied on for knowledge. She had the procurement department, who she seemed to work solely with, and excluded Treasury department. She also had the finance department, who were there long, who knew the whole balance sheet of the organization. And she had the legal department, so she could have, there would have been many people who've been there long enough to get the information she required. Thank you.
Your reference to the legal department reminded me of a question I meant to ask you a little while ago. You had the feedback from National Treasury in early January that this was beyond the mandate of the FDC. You also had Mr. Lusenga raise the concern about a legal due diligence needing to be done on the FDC on the 11th of December of the previous year. Are you aware whether the internal legal department at SAA was then tasked to come to a determination about the mandate of the FDC between January and April?
No, Chair, I was totally unaware because we kept following up what's happening with the matter. Once we gave the final analysis to Ms. Nhansi, she said, leave the matter with me, and that's where it stayed. So we didn't get feedback. If she gave instructions to the legal department to do the due diligence, we were not aware. I was not copied on anything, and I was totally unaware. Thank you.
Chair, I see we are at 1 o'clock, if our watches are aligned.
Yes.
If it's an appropriate time.
Let's take the lunch adjournment and we will resume at 2. We adjourn.